Yay. It's great to see you.
Oh, great to see you.
So let's figure out, do we have an ETA for Ms. Patterson?
I texted her at 2 minutes ago. 2 more. At 12:34.
Okay.
Maybe, okay, yeah.
So Ms. Dyson, we don't need to have a bond hearing?
Correct, Judge, I believe she's out. I'll double check that.
We can ask, did you all bring a Ms. Dyson over from?
Is that female?
Yes.
Oh, yeah.
All right. Then the only one I know who wasn't transported is Mr. Stokes because he's ill. You know that too. You got the email. So if Ms. Dyson wasn't transported, she must be out.
She was really somewhere to the 10th. She was
Okay.
on hold.
To a hold.
Yes.
Oh, okay. Well, she's not at ACDC. So does that mean she was able to make her bond and then that allowed her to go deal with other business?
It looks like she posted the bond and yes, transferred.
Okay.
Whatever county this is. Okay.
All right. Well, we could do one of the other bond hearings while we're waiting on Ms. Patterson. Once Mr. Arca gets here, we'll do your plea, assuming that's a plea. And I think Mr. Richardson and Ms. Castillo are on their way as well. So we'll do those when they get here. I came out to do Torre, but since I'm out here, as long as we've got all the right players for any of these bond hearings.
Your Honor, I believe, I apologize for interrupting. I believe most of the bond hearings are for Ms. Willingham.
Okay.
She went back to her office to retrieve the file from Mr. Arthur.
Got it. Okay.
Excuse me, Judge, may I ask a question?
You may.
Mark Gardner for Mr. Bradley. Are you handling bonds and then we're doing the arraignment calendar?
So I was just trying to fill the time. I was actually supposed to be taking a plea right now or doing something with a case. And we're missing one piece to that equation. So we're holding on that. I'm happy to do the plea and arraignment calendar. I just didn't, it's not quite one yet. So no one is late yet. And I didn't want to get out ahead of things. Who do you have?
Well, we have Bobby Bradley. Mr. Harvey and I are both on there for Bobby, but we represented him for bond only. We found out, of course, last week that we had a report for plea and arraignment, but I talked to his parents and his mom, and she can't afford to pay us. So both of our offices filed motions to withdraw.
Okay. Well, we'll work through that. We'll bring Mr. Bradley out and we can take care of that. I'm pulling up the case right now. Okay, I see a motion to withdraw that Mr. Harvey filed. So are you staying on the case or you are seeking to withdraw as well?
Yes, I'm seeking to withdraw as well, Your Honor.
All right, so you're going to file something?
Well, I thought my assistant filed it yesterday and we sent an order to your assistant, I do believe.
Okay. Nothing's in the docket. That doesn't mean you didn't send something to my team, but the docket has Mr. Harvey's motion to withdraw filed yesterday. If you filed it late yesterday, it may not have hit the docket. I'm not doubting you want to withdraw. We'll just need to make sure that there is sufficient paperwork in place. And we'll still talk about it with Mr. Bradley today when we bring him out.
Okay.
Good. All right. Ms. Wood.
Just for the court to know, he has a 23 CP case where he is retained Renee Rockwell. Ms. Nelson and I inquired with Ms. Rockwell if she was going to be hired on both, and she just didn't have the definite answer yet.
Okay, what's the CP number?
23 CP 215429.
All right. Okay. That's interesting. So when did he? Oh, so he got his bond back in 2020 in the case that Mr. Gardner is on. So it's a blast from the past. Got it.
Yes, Your Honor, and I hate to say this, but we actually did forget about it. It happened right before COVID.
Hey, you did what you needed to do. I mean, you moved on. You services rendered. I get it. It's a long time ago. All right. Well, we'll talk to him about it.
And that is ADA Willingham's case as well, Your Honor.
Okay. All right. Well, according to the network, it's 1 o'clock. Apparently that clock is slow by a minute and a half. So why don't we get going? Ms. Primovic stepped out. Is she gonna?
I think I can.
You can handle? All right.
I think so.
We'll start with plea and arraignment. So position 1 is Mr. Furlow. If he's here, can we? Whoop! Everyone's standing up.
I gotta pull all of them out of here.
Okay. Oh, are they meeting with Mr. Torre right now? Is the interpreter back there?
Yes.
Let's not bother them.
Okay.
Let's get some announcements. We may just bring some people to the door in a little bit and we'll just get announcements on these, but I'd love to have them keep talking. So, Mr. Furlow has been in jail forever. So help me understand how we're only at plea and arraignment, maybe because he was in Henry County. And is this your case or you are announcing for Ms. Feely?
It'll be.
Okay.
So yes, he has been in our custody and then he had a case in Henry County that was indicted, so he's taken there. He's been there a significant amount of time. He was brought back here after resolving that case. Unfortunately, he has some other business pending in Cobb and Cab that is related to Fulton and Henry cases. Mr. Jordan and I have already started working on this. I already have discovery. There's also a 20 CP case.
Oh yeah, his booking number is a 20. Well, yeah. And it's different from this? Because this is a 20 CP case.
It's similar, it's the same charges, but different.
A different incident.
Yeah, different incidents.
Okay.
So, with that being said, Mr. Jordan and I are working to have a resolution ready. I think I'm going to probably have to speak with Mr. Furlow about waiving indictment on the CP case.
Okay.
So that we can get this rolling, so we can then go to Cobb and Cab.
So was Henry County an armed robbery?
Yes, Judge.
And it was resolved as in there was a plea, or Henry County said, Fulton has him, we'll dismiss?
There's a plea to the indictment there.
Okay. So then he may be in a position to have a series of pleas around the perimeter.
Yes, Judge.
Okay. You'll talk with him. Presumably he wants to waive arraignment. If not, I'm happy to arraign him. But we'll take care of arraignment, get a scheduling order in. But it sounds like before some of those deadlines, we may be seeing Mr. Furlow to get him on his way.
Correct.
Okay. And is he ours right now? It says loan out to Henry County. He's now staying here. Okay. Got it. Okay. Waive and schedule. All right. And I'm happy to talk to Mr. Furlow if he wants to say, hey, judge. I'm sure he doesn't. But you should certainly talk with him and then let us know how he wants that to work.
Thank you, Judge.
All right. Mr. Stokes, not brought over.
I apologize. Since position 1 also has position 7 as its co-defendant.
Oh, hold on. Why is that?
Ms. Raven Young.
Okay. Usually they're next to each other. Yes, we should take care of that. But Kenya Bryant, I'm sure, is not Ms. Young's attorney.
I believe Ms. Young may have appeared in court before when we had Mr. Furlow and Mr. Belcher. They were all on a previous plea and arraignment calendar, I believe, and she may have already appeared in person. This is one, Your Honor, where I've been talking with Ms. Wood.
Well, before we go any further, where's Ms. Young?
Did we handle her arraignment?
I thought we may have. Let me look this up. Because I think you may have said this is someone who could be resolved. And so Ms. Walker had said, oh, I'll help with this. I learned from Ms. Walker last night that the lawyer they were going to get to be Eric Johnson won't be in here after all. And we're going to be getting C3 lawyers for all our C2 cases. Interesting approach.
Does that mean that because I know Your Honor sent this, does that mean that Ms. Walker can't handle some negotiated pleas?
She claims that she will continue to work on, you've been copied on all the ones that were yours. Raven Young. She's been on 3 plea and arraignment calendars. And it still says Kenya Bryant. I'll share this with them.
Your Honor, I've been discussing both with the Ms. Wood and the ADA out in Cobb County. We believe that if Mr. Furlow does eventually take accountability for the armed robberies, that there may be something to work out with Ms. Young, both here and in Cobb County. So that
Ms. Young is facing charges in Cobb County as well.
It was a string of armed robberies, Your Honor, and I believe that she's alleged to have been the getaway driver in every single armed robbery. But we are working to see if Mr. Furlow is going to take responsibility, then we may very well be able to work something out with Ms. Young for a plea to a lesser sentence, Your Honor.
Okay, well, she's not here and she got notice to be here. So I'd ask you to put together a bench warrant. I will include that in my email to, I hope they're not my former friends, but the people doing C2, C3 stuff to try to cover things in here to say, here's another drop ball.
Understood, Your Honor.
Okay, Raven Young. Thank you for linking the two.
Yes, Your Honor.
All right, so Ms. Wood, you'll talk with Mr. Furlow and we'll see what he wants to do today.
Yes, Judge.
All right, so position 2, Mr. Stokes, not brought over, not feeling well. Have you had a chance to talk to him?
I have, Judge. I'm comfortable going ahead and doing the waiver of arraignment for him so that he's moving. He
Great.
also has a CP case. So I will be speaking with, is this Ms. Williams? I'm sorry.
We're on position 2 on the plea and arraignment calendar. It is.
Oh, perfect. So I'll be speaking with the state about.
Great.
Global resolution.
So you'll do a waiver. Thank you. Aquarius Crump. And that one, Mr. Lewis is trying to withdraw from.
Yes, Judge. I'll be handling that one today, and I have a new offer. I do want to speak with him to see if he wants to resolve today.
Great. Seems like that kind of charge. Thank you for stepping in. So it will be at a minimum, a waiver and scheduling order could be a plea. All right. And then, oops. So you have filed a notice, you're in the record now as this calendar came out before. That's been addressed. You've substituted in.
Yeah.
I need to grant Mr. Lewis's motion. Was he not with your office at one point?
Mr. Lewis.
Yeah. Or maybe he was a C2 lawyer. He used to be someone who would get appointed.
Teacher, C3, and now he does private stuff.
Okay. Now we're at Bobby Bradley. He is someone we'll need to bring out. So now that you all are done talking with Mr. Torre, could we bring Mr. Bradley out, please? Thanks.
Let Mr. Perman go and you get ready.
Sure. Will Mr. Bradley, if requires appointed counsel, be yours, Ms. Wood, or Ms. Feely / Primovic?
It'd be mine.
Okay.
I'm not Bruce Harden.
Hey, Mr. Bradley, I'm Judge McBurney. How you doing? Mr. Bradley, you've got two cases. One has been indicted and has been assigned to me. It's an old case. And the gentleman you see on the screen there, Mr. Gardner, was one of your lawyers who helped get you a bond a long time ago. He and Mr. Harvey did. You have a new case that's not yet indicted that I've been told, and the system shows you retained Ms. Rockwell to represent you on. Mr. Gardner and his colleague, Mr. Harvey, have both filed motions to withdraw from your indicted case, the one you and I are going to be working on. They represented you solely for purposes of bond almost 3 years ago, 2.5 years ago. They did what they were supposed to do, and your case just sat around. It's now been indicted, and they were the lawyers of record because they had to enter appearances to help with your bond. And they got these notices saying, wait a minute, we're just helping Mr. Bradley with a bond. So they are withdrawing from the case, which leaves you with no lawyer in the indicted case. And I need to understand from you whether you plan to hire Ms. Rockwell for the indicted case as well, or if you're only going to be paying her for your unindicted case, in which case we need to decide, do you need appointed representation? Are you following? I just laid a lot on you. I want to make sure you're following. So you got two different cases, and one of them is really old, but only recently got indicted.
Okay, I would have to see my parents would help me. I
Is it your parents who paid for Ms. Rockwell on the, do you know what I'm talking about with the other case?
Yes, sir.
Okay, and if it's helpful, we could talk about charges instead, but you've got one case with no lawyers now. That's the one that is here. And then the newer case, you have Ms. Rockwell. So you're going to talk with your folks to see if they plan on hiring Ms. Rockwell for the other case as well?
Yes, sir.
Okay, it often makes sense to have the same lawyer working on both, but sometimes people's finances are limited and they can afford a lawyer for one. And then on the other, we appoint lawyers. You'll get a good lawyer either way. I just need to find that out. So I think what we'll do is maybe bump this a few weeks, bring you back so that you and your family have time to see if you're going to hire Ms. Rockwell for the indicted case. I don't want to wait too long. You're in jail and we need to make sure your cases are moving along, but you do have the right to select your own lawyer if you can afford that lawyer. So if we bring you back in a few weeks, is that going to be enough time or do you need more time?
Probably more time. I have to speak with my parents again.
Okay. Is that difficult? Is it hard to reach them or?
No, I just want to make sure that they will have a restraining fee by the time I do come back to court.
Okay. Well, maybe we'll put it out about a month, but I really don't want it to go too far because I want to stay focused on this. I'm not rushing anything. If it turns out that your parents and Ms. Rockwell talk and they can't put together the money for Ms. Rockwell to work on this case, I will appoint a lawyer to represent you. But if 4 months from now, your parents have the money, Ms. Rockwell can always slide in and take over. But what I don't want to do is make you sit in jail while your folks try to scrounge up the money and then nothing's happening with the case. So it's not a problem to switch lawyers. But you may work with the appointed lawyer and say, this is great. Why would I pay for a lawyer? I'm getting one who is taking care of everything that can be done for me. So I won't appoint anyone yet because you're asking for some time, but I'm going to keep it at about a month. We'll bring you back here and you'll let me know what you and your family were able to work out. Does that work?
Yes, sir.
Okay. I will see you in about a month.
Thank you. Thank you.
Sure.
That concludes my business here. May I be excused?
Yes, sir. So you're pretty sure that you've sent something to Ms. Nelson that is a proposed order that gets you off the case?
Correct. Well, I just checked it and she sent an order to your office for signature, but didn't file a motion, but she just filed the motion at 1:06.
Then you're all set. I'll take it from there. Thank you.
Thank you, Judge.
Xavier Frisson.
Mine, Judge.
Okay.
I believe Ms. Nelson said that we could have a bond motion or bond hearing on this today.
I don't mind that. That would be more whether Mr. Abate knew that that was coming, assuming this is his case.
I didn't know she was on the email, so I'll be prepared.
Okay, we'll do that. And I'll just add that to the list of bond hearing, but we'll also, I assume he's going to waive arraignment, et cetera. We won't skip that step.
Yes.
Okay, good. Let me just write one thing down. Okay, so we'll hold off on that. Francisco Arias.
Your Honor, Attorney Ghazi emailed both Ms. Nelson and I a waiver and also an entry. He said he was not able to file it for some reason, but he did send it to both Ms. Nelson and I on Tuesday. He also stated that Mr. Arias is currently in the Department of Corrections.
State.
Yes, Your Honor.
Okay, got it. I don't know about the not being able to file it. That that's confusing, but if he got it to Ms. Nelson, she can file it, I know. And that will get the case moving along. It got transferred to us.
That's right, Your Honor. I do believe it was a non-complex. And it was trying.
Oh, it's a repeat offender. Big time. Okay, got it. Ms. Nelson, did you get the waiver of arraignment and entry from, or at least waiver from Mr. Ghazi?
Yes, I did. I had reached back out to his office, asking him to complete your waiver of arraignment. He has not responded, so I guess I'll file the one that he filed.
Okay, as long as it has the magic W word in it, that'll waive it and we can get a scheduling order out. Thank you. Did Raven Young make it? There's Raven Young. How are you? I didn't recognize the blue things. Ms. Young, no bench warrant for you. What do you know about a lawyer? I didn't think so. That's not your fault. I made a note to reach out to the folks who are supposed to ensure that you've got a lawyer. Mr. Furlow has the public defender, so you can't, because that would be a conflict. You need independent representation. I think I told you before, I don't think she was in court when you were, but there's a woman, Ms. Walker, Joy Walker, who is what we call a conflict defender. And she had said she would work with you because Mr. Jordan, who's seated in front of you, had said he thought your case was pretty work-outable. It's not really a word, but resolvable. But you need a lawyer to help guide you through that. I was hopeful Ms. Walker would be able to do that. She is someone who's pulled in lots of different directions. She's a supervisor over a bunch of lawyers, but I'm going to revisit that and see what they're going to do to get you a lawyer. It's their job to get you a lawyer. And I think I still have your contact information because I think you gave it to me. It was probably just phone number and email address because I then gave that to Ms. Walker, and then I'll make sure we do something about that. And I just have to reset your case again, unfortunately. I don't mean to keep dragging you in here, but they are serious charges, and better to be on bond where you are than where Mr. Furlow is. I'm guessing you're enjoying things more than he is. So what I'm going to do is set this out about another 30 days. Did you get something in the mail telling you to be here?
I also need to switch the address.
Okay, there's a change of address form here that the deputy's going to give you. And if you'd fill that out and then just get it back to the deputy, I'll make sure it gets filed. Chase Elliott. I understand this has been resolved or will be resolved now. Who do we have online handling that situation?
Judge, this is Hallie Dixon from the Attorney General's office. I'm here for the prosecution.
Hey, Ms. Dixon, and who represents Ms. Elliott?
Katrina Spearman, and I see her name on here, Judge. I don't see her face, but I see her name. Great.
Well, she will resurface. She will hopefully appear in a moment. Ms. Spearman, you there? Well, I'm going to let her figure out how to turn on the audio and video. Ms. Dixon, how about, is Ms. Elliott on? She's a little more important.
She is definitely important.
I see she's there too. My understanding is that this is going to be a plea today.
That is my understanding, Judge.
Okay, well, I'll need Ms. Spearman to confirm that, and then we will put it in the queue to take care of today.
Thank you, Judge.
Sure. Thank you. Emporia, is that right? Loop. Got it. Phone number is the same? You changed your phone number? Okay, that doesn't go in the system, but I'll need it. Why don't you write it down on here? Because I need to give it to Ms. Walker. But you're changing everything. Mr. Dawson, your lawyer is parking, so it's not stuck in traffic. He's nearby. Thank you. All right, Ms. Young, you're free to go. Thank you for that.
I'm so sorry, Judge. This is Katrina Spearman. I was struggling to find my mute button.
All right, you found it. Ms. Dixon says that Ms. Elliott is prepared to enter a plea in her case today. Is that correct?
That is correct.
Excellent. We will do that in a minute. Let me just get through the calendar to figure out what else we've got. Okay?
Okay, thank you.
Thanks. Quindarius Rhodes. See Mr. Rhodes there. Hey, Mr. Rhodes. So what did you figure out, Mr. Rhodes? Who's representing you on this new case?
I got to retain a different lawyer.
Not Mr. Smith?
Yeah, it's too confusing for him.
Pardon me?
The case was too confusing for him.
Okay, it's confusing to me. It looks like it's about 500 counts, but that's how Mr. Hiles rolls. Have you already hired someone, or you plan to do that?
I plan to do that, but I need like a little more time. I need to work.
Okay. What do you do for work?
A warehouse job.
All right. How much time is a little more time?
I need like 30 days if I can have somebody retain.
Okay. Why don't we set this out about 45 days just to make extra sure? Mr. Hiles, you all right with that?
That's fine. And if he gets an attorney before then, just let me know. And has he already been arraigned? I mean, I didn't know if Mr. Smith.
I don't think so. I think Mr. Smith kept his hands off, and didn't handle the arraignment, but let me look. I think this was back on for a hopeful arraignment with Mr. Smith at Mr. Rhodes' side, but Mr. Smith was clear as recently as yesterday that that's not the case. So nope, no arraignment yet. So what we'll do is set this out, Mr. Rhodes, about 45 days for another plea and arraignment day. You'll need to come in for that with your lawyer. If you haven't been able to raise funds for it by then, I'm going to appoint a lawyer for you because I don't want this case to slow down any. Okay.
All right.
Mr. Hiles, anything else for the state in this?
No, Your Honor, that's all I have for today on this calendar.
Okay. Well, it was nice seeing you.
And one matter that's not on the calendar, I just want to bring to your attention. As I was coming up to court today, I got my snail mail, and our friend Mr. Tyrone Robinson has a new attorney that just substituted.
Who's that?
Marcia McNaught or McNo. I don't know how to, but I just went ahead and we're going to drop the discovery in the mail today.
Who was the lawyer just before that?
Arnold Regis.
Oh, okay. I'm aware of this. I asked to get one. No, I didn't know that. Mr. Regis was clear that he was keeping the case. And so Ms. Mignot.
Private attorney.
This must, okay, I'll work through. I'm not going to change it. That's the lawyer who's filed an entry. That's not through our C3 project, though.
I don't believe so.
I know it's not, because that was one when I asked which cases we could have back, because the Regis name was on 500 cases.
Right.
That was one where he said, I'm keeping this case. And I guess I meant GPDC is keeping it and Ms. Mignot has it now, or however one says that.
Yeah, so
okay.
It's just easier and more streamlined to send it discovery from us on a thumb drive.
Okay. Thank you for doing that. That is not it is a star-crossed case. It is not a star-uncrossed case.
Yeah.
Okay.
All right.
Thanks.
You, Your Honor.
So, Mr. Rhodes, you are free to go. Did you get something in the mail? I know you were here yesterday, but did you get something in the mail about this case?
Oh, I ain't got nothing but a court paper in the mail.
Nothing but what?
Nothing but a court date.
Yeah, that's what I meant. You get things in the mail telling you when to come to court.
Yes, sir.
Good. That's all we send you. I don't send you anything else. You don't get candy or flowers from me, just court dates. So we'll send you another court date. It'll be about 45 days out, okay?
All right.
You are free to go.
May I please be excused, Your Honor?
Yes, thanks for the update on that other one.
Yeah.
And finally, Christopher Getter, and I apologize if I mispronounced the name. I'll be surprised if he walks in. I think he's in the van down by the river still. Ms. Hall? How are you? I am doing all right. There's a bench warrant in place, so there's nothing you need to do. It will stay in place. And hold on one second, mute Ms. Jordan there. We'll see what we can do. If he had come in, probably would have set it aside, but he's not here. And the day's still young. We'll see. Yeah. You don't need to stick around though, Ms. Hall. If he shows up and it starts getting substantive, I'm sure Ms. Willingham or Mr. Jordan will hit the panic button and you can come steaming in here. Okay? Thank you. So, I think we have with Ms. Patterson here, everyone we need to handle Mr. Torre, and we've got Carlos waiting on that. So I would like to take that plea, and then we've got everyone in place for Ms. Elliott's plea. So we'll do that. And I think I see Mr. Arca back there. So we could take Mr. Dawson's plea and then move on with other stuff. Yeah.
So Judge, there's been a change in circumstances. I was able to speak with Mr. Dawson a little bit more about his case. And he will lose his job. It's a government job. Works hard. And we're currently discussing the consequences of taking the plea. He's got a pending case out in Carroll County. So.
What are the charges in Carroll? Are they also felony case charges in Carroll?
Correct.
Okay.
He only has the option of using first offender on one case. So,
true that.
So
unless one of the cases is a drug case, which this one is not. Okay.
So it's come down to this moment where we got to decide trial, or unless the states want to go ahead and reconsider. But if I can just have 5 more minutes to discuss it.
You got time. We've got 2 pleas ahead of you, or a disposition and a plea ahead of you.
All right, then I should have that. Should be enough time.
Please do. Okay. All right. I think so. Before we bring Mr. Torres out, I need 2 things. One, I need his indictment number because I didn't bring that piece of paper with me. Oh, wait, I may have it before you. I'm doing that. I've got it. So I've got that. What are we doing?
Your Honor, I did communicate a misdemeanor resolution to that case. I have been told previously by Attorney Feely that Mr. Torre may struggle through the plea, but that's where the state stands currently. So we are going to try to move forward with a negotiated plea from the state side, Your Honor.
To a misdemeanor?
Yes, Your Honor.
Okay. Ms. Primovic, you were able to spend a little time with Mr. Torre just a few minutes ago. What's your forecast as to whether we could get through a misdemeanor plea?
It's gonna be close.
Okay. Keep hope alive.
Keep hope alive.
Let's try it. All right, Mr. Larios, I shall press you into service. Would it be better to print the indictment out so we could put an X on it, or would it be better to ask him, is it okay if we sign for him? It's an extra question.
Yeah, let's print it.
We'll print it.
Yeah.
Okay.
Great idea.
Every once in a while. I assume this gets him out.
Yes.
Okay.
That's correct. And Your Honor, just to give you a heads up, Mr. Torrey, I've been told is a Cuban national.
Exactly.
So to avoid flagging him to any kind of immigration, we want to offer an 11-month, 29-day sentence.
Good.
Under the 12 months.
Let's just do 11 months. Let's not even get into days. 11 months.
Understood.
One moment.
Okay.
I'll get rid of all those.
Are we ready?
Yes, Your Honor.
Okay. I'm going to swear Mr. Laris in first. Do you swear or affirm that you will translate faithfully and to the best of your ability from English to Spanish and Spanish to English? Thank you. Good afternoon, Mr. Torre.
Good afternoon.
I may say things to you today in English that you understand,
Habrá algunas cosas que quizás entiendas en inglés que yo voy a decir.
but please wait until Mr. Lares translates them to Spanish before you answer. So, Mr. Torre, I need you to answer out loud when you do answer Mr. Lares's questions.
Yes, okay.
Great. If you ever have a question about what we're talking about, will you let Mr. Lares know?
Yes.
Thank you. Mr. Torre, in a moment, Mr. Jordan, who's the prosecutor, is going to ask you to swear to tell the truth.
Te va a juramentar para decir la verdad.
After that, we're going to have a conversation about how to resolve the case that's been keeping you in jail for so long.
Luego de eso, va a haber una conversación sobre el caso, el que te ha tenido preso todo este tiempo. Okay. Yes.
And the plan is to get you out of jail and into a program with housing and support.
El plan nuestro es sacarte de la cárcel y enviarte a un lugar donde te van a recibir, donde vas a hacer consejería, un programa. Okay.
Is that something you'd like to do?
¿Algo que quisieras hacer entonces? Yes.
Great. For that to happen, you need to answer some questions about your rights as a defendant.
Entonces, para que eso pueda suceder, tienes que responder algunas preguntas que tienen que ver con los derechos que como acusado tienes. Yes.
Great. And Mr. Jordan, before you swear Mr. Torre in, my thought is that we could stipulate to the factual basis as well, just so there's less going on. I'm very familiar with the facts, having reviewed Mr. Torres's case a bunch.
Absolutely, Your Honor.
Un esposo. Sabe también que no ha sido fácil para mí entender todo lo que ha pasado.
Okay, that was just an update. He didn't need to agree to that. Okay,
I just, you know, I just translated it.
yep, thank you. When you're ready.
And Your Honor, this will be a plea to only count 3 on the indictment, which is simple and so.
Okay,
El servicio fiscal acaba de anunciar que solamente para
Mr. Torre, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Que la declaración que vas a decir hoy aquí después es la verdad, toda la verdad y únicamente la verdad. The truth.
Can you please state your true, correct, and legal name?
Dimos entonces, la primera pregunta es, ¿cuál es tu nombre y cuál es tu apellido? Dime en voz alta. ¿Tu apellido? My name is Cristóbal Torres.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
¿Estás en este momento, Cristóbal, bajo los efectos de alguna medicina que te dieron para poder llegar aquí? ¿Has tomado alguna droga? ¿Has tomado alcohol? No, no.
Is there a medication that you normally take that you have not been given today?
¿Hay un medicamento que te han estado dando normalmente, pero que hoy no te dieron? No.
Mr. Torre, do they give you any medicine at the jail to help you think well?
En la cárcel te han estado, Torre, dando algún medicamento que te ayuda a pensar bien, a estar tranquilo. ¿Qué te han estado dando? They're only giving me something for diabetes.
Okay. And did you take that medicine today?
¿Y hoy te tomaste ese medicamento? Yes, today.
How old are you and how far have you gone in school?
¿Cuántos años tiene ahorita y hasta qué grado de escuela llegaste? Sexto grado. I am 65 years old and I did 6th grade.
Is English your native language?
¿Es inglés tu idioma nativo? No.
Do you understand that an interpreter has been provided to assist you?
Por eso estoy yo aquí como intérprete para asistir. ¿Entiendes eso? Sí o no? Yes.
Do you understand that you have been charged with the offense of simple assault?
¿Entiendes entonces que estás aquí preso por un cargo de agresión simple? ¿Entiendes eso? Okay.
Do you understand that you have the right to plead either guilty or not guilty to this charge?
¿Entiendes que a este cargo lo único que tienes puedes admitir culpa o quedarte como no culpable? ¿Entiendes eso? ¿Sí o no? Yes, I understand.
And if you pled not guilty or remain silent, you would receive a jury trial.
Si, por ejemplo, no hubieses dicho nada, hubieras quedado en silencio, o hubieses dicho, yo soy no culpable, hubiésemos tenido que tener un juicio ante un jurado. ¿Entiendes eso? Sí o no. Okay.
Have you had enough time to speak with your lawyer, Ms. Marilyn Primovic, about all of the facts and circumstances known to you regarding the charge in this indictment?
¿Tuviste ocasión de hablar hoy con tu abogado, la señora Marilyn, señora Primovic, sobre tu caso, sobre tus cargos? ¿Tuviste chance de hablar con ella? Yes.
And I'd like to add, his usual attorney, needs a feeling, if you had enough time to talk to her.
La abogada, en realidad, que ha atendido la señora Patricia Field, Bueno, quién es ella, ¿verdad? Ella es diferente. Ella ha ido a verte, ha estado en contacto conmigo, ha hablado conmigo. Y se está dejando.
Okay.
Do you need, I'm sorry, did you? Is everyone good to proceed?
Yeah, Mr. Torre, you may have talked with more than one lawyer, which is okay.
Dice el juez, señor Torres, a usted lo fueron a ver quizás varios abogados durante todo este tiempo, ¿verdad? Él dice, eso no importa, eso está bien. ¿Ha sido así? Yes.
Okay, but you feel like you've had enough time with lawyers to know that you want to go forward today.
Has estado entonces durante todo este tiempo con los abogados que has hablado, los abogados que te han visto, tú recuerdas, eso te ha ayudado, ¿verdad? Te sientes que hoy entonces puedes continuar aquí con esta abogada, ¿sí o no? Yes.
Do you need any more time to discuss the case with your attorney?
Necesitarías parar esto para hablar otra vez con tu abogado sobre el caso. No.
Are you satisfied with her services?
¿Estás satisfecho con el servicio legal que has recibido aquí? Yes.
Ms. Primovic, do you waive formal reading of the indictment and also waive any and all defects in the indictment?
Yes, sir, we waive both of them.
Mr. Torre, do you remember? I'm sorry, my apologies, go ahead.
What's he doing? What's he doing?
Sobre este proceso, continuar en este proceso. Y si ella tenía que revisar algún documento, y ha dicho que ella no va a revisar.
Mr. Torre, do you remember having being arrested on this charge?
¿Recuerdas cuando se arrestaron? No.
It was a long time ago. It was something that happened at a gas station and then you got arrested. Do you remember going to jail?
Dice el juez, eso ocurrió hace algún tiempo atrás en una gasolinera, hace tiempo atrás, ¿recuerdas? Yes, I remember.
Okay.
Your Honor, the state is unaware of any outstanding warrants related to this charge.
Me neither.
Yes, Your Honor. And Ms. Primovic, do you know of any outstanding warrants related to
No,
this
sir,
charge?
I do not.
No sé, ni he visto que haya contra ti, doctor, ninguna otra orden de arresto, ningún otro caso contra ningún otro lugar. Le pregunto a tu abogado si ella sabía de alguna nueva cosa que ha dicho que
Mr. Torre, has your attorney advised you the minimum and maximum sentence for the charge that you were pleading to?
Señor Torres, le explicó o le dijo su abogado cuál es la pena mínima de cárcel, cuál es la pena máxima de cárcel ahora por el cargo único de que hay que bajar el culpa aquí. Yes, she explained it to me.
And Your Honor, just for the record, for simple assault, the minimum is 1 day and the maximum is 12 months in custody.
Hasta de la audiencia que ese es un delito que está penado todo aquí mínimo con un día de cárcel, máximo con 12 meses de cárcel. Okay?
Mr. Torre, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence?
Señor Torres, esta es una sentencia que negociamos para usted con su abogado y el señor fiscal. Él le va a recomendar al juez la pena de cárcel. ¿Entiendes eso? Okay.
Your Honor, the state will be dismissing counts 1, 2, 4, 5, and 6. As to count 3, the state's recommendation is 11 months to serve, credit for time served.
Le dice al juez, Voy a anular, el cargo número 1, el cargo número 2, el cargo número 4, el cargo número 5, el cargo número 6. Él lo está anulando. Solamente queda un cargo y vas a meter culpa a ese cargo. Es un delito menor y le están dando crédito por tiempo ya cumplido. El pasado en la cárcel va a cubrir la asistencia. ¿Tienes eso? Ok, yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Entiende todo. Por admitir culpa, hoy aquí, ahorita lo vas a hacer, renuncias a tener que presentar para defenderte tu defensa. Inclusive no hay ni siquiera que decir que tenías problemas mentales, que los tuviste cuando pasó eso. ¿Entiendes eso? Yes, I understand.
Do you understand that if you went to trial, you would have the right to a trial by jury?
Si entonces hubiese habido un juicio, si hubiese habido un juicio, hubieses tenido el derecho a que ese juicio hubiese sido con un jurado. ¿Entiendes eso? Yes, I understand.
The right to see, hear, and confront witnesses called to testify against you?
Hubieses tenido el derecho en ese juicio, si hubieses tenido a ver, a oír, a interrogar a los testigos que hubiesen venido a declarar en tu contra. ¿Entiendes eso? Yes, I understand.
And the right to testify or to remain silent and not incriminate yourself.
Y también renuncias al derecho en ese juicio, si lo hubieses tenido, a tú declarar. Renuncias al derecho a haber estado en silencio. ¿Entiendes eso? Yes, I understand.
Do you understand that by pleading guilty, you were giving up the following rights, which I will now list off? Would the interpreter prefer for me to go all at once or go one by one? One by one.
Entonces él dice, como vas entonces a renunciar a todos los derechos, porque vas a admitir culpa, él entonces te va a volver a repetir, ya te lo digo ahorita, cuáles son los derechos que vas a renunciar para después aceptar tu admisión de culpa. ¿Bien? Ok.
The right to a trial by jury.
Renuncias al derecho a haber tenido un juicio por eso. ¿Entiendes eso? I understand.
The right to remain silent and not incriminate yourself.
El derecho a permanecer en silencio, a no incriminarte. ¿Entiendes eso? Ok.
The right to confront witnesses called to testify against you.
El derecho a encarar o enfrentar a cualquier testigo que hubiese venido a declarar en ese juicio en tu contra. ¿Ok?
The right to the assistance of counsel hired by you or to a court-appointed counsel if you could not afford an attorney.
Igualmente, renuncias al derecho a que un abogado en ese juicio, si lo hubieses tenido, no hay un juicio, entonces renuncia a que te represente un abogado, uno que hubiesen contratado con dinero para ti o uno que hubiesen asignado al tribunal, así como la señora que está a tu lado. Renuncias a ese derecho. ¿Entiendes eso? Ok.
The right to the presumption of innocence.
Renuncias también a la presunción de inocencia, es decir, ya no eres inocente. ¿Entiendes eso? I understand.
The right to testify on your own behalf and to present other evidence.
El derecho a declarar y a presentar otras pruebas si las hubieses tenido. ¿Entiendes eso? Ok.
The right to subpoena witnesses and compel the production of evidence.
El derecho a presentar por orden del juez a testigos si lo hubiese habido, que hubiesen dicho otra cosa. El derecho a presentar otras pruebas. ¿Entiendes eso? Yes, I understand.
The right to have the charges against you proved beyond a reasonable doubt.
Y renuncias al derecho que tienes de obligar al gobierno en ese juicio, si hubiese habido uno, a demostrar, más allá de toda duda razonable, que cometiste un delito. ¿Entiendes eso? Okay, yes.
And finally, the right to appeal if convicted of these charges after a trial.
Y finalmente, el derecho a apelar la decisión del jurado en ese juicio si lo hubiese tenido. ¿Entiendes eso? Yes, I understand.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
Alguien te prometió alguna cosa, alguien te amenazó, alguien te presionó para que hoy, aquí ahorita, admita lo que eres culpable. No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Entonces, tú decidiste renunciar al juicio, a esos derechos y admitir culpa a este único cargo ahora. Yes, yes.
How do you plead to the charge of simple assault in indictment 16 SC 149, my apologies, 16 SC 142927?
El fiscal, ¿cómo te declaras ahorita entonces a ese único cargo, a ese delito menor? El caso, ese cargo que te quede, ¿culpable o no culpable? Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charge against you?
Estás entonces ofreciendo tu admisión de culpa de manera voluntaria, de manera libre, entendiendo cuál va a ser entonces el resultado final de lo que estás haciendo. ¿Sí o no? Yes.
You understand that you only have a limited right to appeal this guilty plea conviction.
Te dice, bueno, te queda un solo derecho. Si lo necesitases en el futuro, es un derecho limitado. Es un derecho a reabrir este caso en el futuro si fuese necesario. ¿Entiendes eso? Yes, I understand.
You understand you have only 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty plea.
El derecho que tienes se llama habeas corpus. Ese derecho te permite reabrir este proceso de hoy en el futuro si tuvieses que hacerlo, para demostrar que no participaste, como estás haciéndolo hoy, de manera voluntaria en este proceso. Te dan solo 12 meses a partir de hoy para usar ese recurso. ¿Entiendes eso? Okay.
And Your Honor, we have already stipulated to a factual basis, so we would just ask that Your Honor accept this negotiated.
Okay.
Puede ser el video que acepte lo que negoció y que, como ya hablamos sobre el caso, que no se tenga que decir.
Ms. Primovic, do you stipulate that there is a factual basis for this plea to count 3?
Yes.
Ms. Primovic, what would you like to share?
Your Honor, we would ask that you accept the 11 months to serve. This has been a long journey. Ms. Patterson from our office has found we don't want him to just walk out of the jail and be homeless and have nothing to do. So Ms. Patterson tell you what she has found and thoughts and things so that he has a place to go to and can continue to get medication and help as he needs.
Should I do a transport order before I sign the final disposition? Because the final disposition would simply release Mr. Torre, and so we may want to sequence it, but I'll let you address that, Ms. Patterson.
I have, good afternoon, Your Honor. I have sent Ms. Feely the order. It'll actually be a release order where Mr. Torre will be released to my custody along with an investigator, and we will transport him to the program.
Great.
She already has that in her possession.
Excellent. And I view that as the equivalent of a transport order, but I think what I'll do is wait to get that and sign that and have you or Ms. Feely let me know Mr. Torre has been successfully delivered. Then I'll sign the final disposition because if you can tell me how to sequence it, but if I sign the final disposition now, we run the risk that you try to pick him up and he's not there, and then we'll be frustrated.
I think soon as we see on the booking sheet that hold has been, then it would be good to sign it. Because they won't release him with this pending. So if it's showing on there, release to, hold, release to Jackie Patterson or whoever, that'll show on this booking sheet.
Okay.
And then if you sign it, it will get rid of all those charges, and then they'll be like, okay, he's good to go.
Okay. I'll sequence it in whatever way is most effective. I think we're having to redo the way we did Mr. Alexandre, and I'll work on that. But I want to get it right for Mr. Torre. So I won't sign the final disposition until you all say sign it, or I'll sign it, but Ms. Nelson won't e-file it.
We'll email her and review it.
Great. Okay.
And I have the order and I can actually send it.
Perfect.
Que le permite a la cárcel entonces entregar a la señora para que primero se maneje nunca a eso.
Ms. Feely just sent the order. That's a little creepy. All right. Mr. Torre, do you have any questions?
No.
Mr. Torre, I find that there is a factual basis for your plea.
Encuentro entonces como el base legal para usted haber aceptado y admitido culpa hoy aquí. Okay?
I also find that your plea is knowing and voluntary, which means you understood what we talked about and that no one is forcing you to enter this plea. Do you agree with that?
Encuentro que admitiste culpa de manera voluntaria, que lo hiciste entendiendo bastante bien todas las cosas. Es decir, nadie te forzó. ¿Eso crees que fue así? No. ¿Nadie te forzó? No one forced.
Okay. Mr. Jordan, I'm going to hand you the indictment. If you would sign it. Thank you. And then we'll get that to Ms. Primovic and Mr. Torre. While that's happening, Mr. Torre, I'm going to sentence you to 11 months.
Señor Toro, entonces no sentencio a 11 meses, ¿ok?
But you've already been in jail for many more than 11 months.
Yo sé que usted tiene preso mucho más de 11 meses.
So you should be released in the next day or two to Ms. Patterson, who is right there behind you.
Te van a dejar salir ahora de la cárcel un día más o 2 días más a la señora Patterson. Aquí, ve, señora Patterson. Okay.
And she will help get you to your new home.
Ella se va a encargar entonces de ayudarte a llegar al lugar donde vas a vivir allá. Okay. ¿Está bien? Yes.
Thank you, Ms. Patterson. And Ms. Feely and Ms. Primovic and Mr. Jordan. I know you had to make some things happen on your side as well. This is long overdue, but hopefully Mr. Torre finds a safe space. I had no idea he was 65. Okay. Adios, Senor Torre.
Here's the side of the
Thank you. He's got a good signature. Yes, ma'am. See you around. Appreciate the green and the orange and all that. I saw that. That's very good. Yep, that's good. Okay. Ms. Spearman, are you and Ms. Elliott ready to move forward?
Yes, Your Honor, we are.
Great. Why don't we do that? That'll free the prosecutors up to meet with the lawyers who need to talk. I see Ms. Castillo here. Is that looking like it's going to be a plea? Great. And then I guess you can give me an update as to what's happening with Mr. Dawson. Was that you also? Okay.
As to Mr. Dawson.
He's right there. He's looking.
Mr. Arca stepped back out, but what he's asking for, I don't have a problem trying to consider, but I don't want to spring that on my victim at the last minute.
Okay.
So I told Mr. Arca that I'm fine with asking for this to be set to maybe a later calendar. I understand we're on the trial calendar, but I don't think it's something we cannot still try and resolve.
Okay, we'll get something, if not on the record, at least I just want to know what's in the works so I can.
It's gonna be a plea today.
Okay, understand. We'll do that. I just wanted, you guys are free to circulate because our prosecutor, our defense attorney, and our defendant are all virtual on this one. Okay, let's turn to position 8, which is 22 SC 185351, State versus Chase Elliott. And let me get all the right folks on our screen here. There's Ms. Spearman, there is Ms. Dixon, and there is Ms. Elliott. All right, and I'm Judge McBurney. So Ms. Elliott is appearing virtually with her lawyer, Ms. Spearman, and from the Attorney General's office is Ms. Dixon. Ms. Elliott, before we go further with your plea, I need to make sure on the record that you are comfortable having your lawyer appearing virtually rather than by your side. Normally, the lawyer and the client are right next to each other because if you need to confer, you can literally lean over and whisper and get an answer. And we can facilitate that by moving the two of you into a breakout room where you can speak privately for as much as you need to. And we'll do that, but I need to get on the record that you are comfortable proceeding with Ms. Spearman connected to you only virtually as opposed to right by your side. Is that all right?
Yes, it is.
Okay, then we will move forward. In a moment, Ms. Dixon is going to put you under oath. Once you're under oath, it's important that you answer her questions and mine, and we'll both be asking you questions truthfully and completely. If you've got any questions of your own, you should ask them. Ms. Spearman may hear the question and say, whoa, we need to go in a breakout room, and you can do that, but it may be something that I can answer or that she can answer in a public setting. But it is very important that you let me know if there's something said that you can't hear because we're going through Zoom, or that just doesn't make sense because you and Ms. Spearman had talked about a particular way this was going to go and it's not going that way. Will you do that?
Yes.
Okay. When you are ready, Ms. Dixon.
Thank you, Your Honor. Ms. Elliott, will you raise your right hand for me, please? You solemnly swear and affirm that the testimony you're about to give to the court today in this matter be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
And Judge, for the record, I believe you've already announced, but we are here on 22 SC 185351, which is State versus Chase Latrice Elliott, formerly, I guess, known as Chase Latrice Jackson. The negotiated plea in this case, Judge, I anticipate, will be that the state will recommend 7 years to be served on probation. We will be requesting a waiver of the fine because we will also be recommending $14,989 in restitution. And I will provide the details of that in a moment. We have agreed to recommend that an appropriate behavioral incentive date would be 3 years from today, should she qualify. And there will be a special condition that she cannot be employed or volunteer with the state agency during the time of her probation. Lastly, Judge, before we get all the way started, based on the information available to us at this time, the defendant does appear to be to qualify for first offender treatment, and I have agreed to recommend that to the court should the court want to consider the state's recommendation.
Can you, I'm going to stop you for a sec. Can you repeat that last thing? You're going to recommend what? It got garbled. What do you recommend?
I'm sorry, first offender treatment, Judge.
Okay.
Based on the information I have right now, I'll cover it in the colloquy, but Judge, to give the court some factual basis for the plea. In summary, between September the 29th of 2016 and November the 6th of 2020, the defendant intentionally submitted 5 false applications to the Georgia Department of Human Services, which is located in Fulton County, and that's where the applications were received. Those applications were to obtain food stamps, and on those applications, the defendant intentionally underreported for income or reported no income whatsoever. At all times during that time and during the filing of those applications, the defendant's income exceeded the maximum allowed to qualify. But due to her false statements and her failure to disclose truthful income on her 5 applications, she was able to fraudulently obtain more than $1,500 each time, which represents 5 of our counts. Additionally, on 4 separate occasions during that same time frame, the defendant knowingly and willfully made and used falsified direct deposit pay stub type emails she got from employers. She then submitted those to the Department of Human Services, which is, of course, a state agency, in connection with her application of food stamps, which is a matter within its jurisdiction. Each of those counts, Judge, these pay stub type things were altered to reflect less income than she actually made, which facilitated the food stamp fraud in essence. Now, and to sort of preclude any possible issue, neither the victim, which is Department of Human Services, any law enforcement agency, or the state were made aware of it or had any idea that the fraud was going on until December 31st of 2018. DHS requested an internal review of this activity surrounding her applications. So that is the first time that it became, or even conceivably could have been made aware to the state, which is when we base our statute of limitations on, Judge. Now, I'm sorry, Miss Elliott, is your true and correct and legal name Chase Latrice Elliott?
Yes, it is.
And do you spell Elliott with 1 T or 2?
2 T's.
Okay. And so sometimes on some things it comes across as Chase Latrice Elliott with 1 T, and sometimes other things says 2 T's, correct?
Yes, I tried to get it changed, but they said I needed to wait until I got to you all in court.
Okay. All right. But both of those names are in fact legally you. Is that correct?
Yes.
Okay. All right. Now, are you under the influence of any drugs, alcohol, or medication at this time that affects your ability to understand what's going on in the courtroom today?
I am not.
And do you suffer from any mental illness or psychological disorder that affects your ability to understand what's going on in court today?
I do not.
And Miss Elliott, how old are you?
39.
39. And how far did you go in school?
I have a bachelor's degree.
So safe to say you fully read, write, and understand the English language?
Yes.
Okay. And are you a U.S. citizen?
Yes.
And Miss Elliott, you have your attorney here virtually with you, I guess. And have y'all gone over the charges in this indictment? Has she gone over that with you?
Yes.
Okay. And do you understand that counts 1 through 4 and count 7 all charge you with public assistance fraud? And that offense carries the possibility of a sentencing range of between 1 to 5 years and up to $100,000 on each count. And then counts 5, 6, 8, and 9 charge you with making a false statement to a government agency. And each of those carries a possible sentence range of between 1 and 5 years up and a fine up to $1,000. So the total maximum sentence on this is 45 years with a possible maximum fine of $504,000. Do you understand that?
Yes.
Okay. And do you understand that you have the right to plead guilty or not guilty to these charges?
Yes.
And Miss Elliott, do you understand that if you plead not guilty and remain silent and refuse to even enter any plea at all, then the state will have to prove your guilt beyond a reasonable doubt at a jury trial? Do you understand that?
I do.
And do you understand that if you plead guilty, you waive certain constitutional rights?
Yes.
And I'm going to kind of go over those with you. Okay. So I'm going to list them. All right. Do you understand that by pleading guilty, you waive the right to a jury trial where you are presumed innocent and the state has to prove your guilt beyond a reasonable doubt. You waive the right to confront and cross-examine witnesses called against you or to subpoena witnesses to testify on your own behalf. You waive your right to remain silent and to testify or not testify. And at a jury trial, if you testify or choose not to testify, excuse me, the judge would tell the jury they could not hold that against you. You also will be waiving the right to an attorney to assist you throughout the trial and the right to an appeal your conviction if a jury, were to find you guilty. Do you understand that you waive all of those constitutional rights by pleading guilty?
Yes.
And do you understand that you also give up any defenses such as a mental health defense by pleading guilty?
Yes, I do.
So, Ms. Elliott, understanding the charges, the possible penalties, your rights, and how pleading guilty affects your rights, how do you wish to plead to the charges in this indictment?
I plead guilty and take the plea.
Okay. And are you entering that plea freely and voluntarily, understanding fully the charges against you?
I am.
And are you entering that plea because you, in fact, are guilty?
Yes.
And has anybody forced you, threatened you, or promised you anything to make you plead guilty?
No.
All right. Ms. Elliott, have you had enough time to speak to your attorney, Ms. Spearman, before today?
Yes.
Okay. And do you need any additional time to speak to her about anything before moving forward on this plea?
No.
And are you satisfied with her services?
Yes.
And Ms. Spearman, do you waive a formal reading of the indictment in this case?
Yes, we do.
And do you waive any defects in the indictment for the purposes of this plea?
Yes, we do. But for the record, we did not observe any defects in the indictment.
Yeah, as well. Thank you. Judge, excuse me, Ms. Elliott, you understand this is a negotiated plea, and I kind of covered that earlier, but I'll say it again, that on count one, we're going to recommend 5 years probation and I guess $14,989 of restitution total.
Yeah.
Okay. Count two, we will be recommending 2 years probation to run consecutive for a total of 7 years probation. And then on the remaining counts 3 through 9, we're going to recommend the court sentence you to 5 years probation, just run it concurrent, meaning totally 7 years of probation. You understand that?
Yes.
Okay, and do you understand there's this special condition we're also recommending about not working for a state agency?
Yes.
Okay, this is negotiated plea, meaning that that's what we're recommending to the court. But do you understand the court does not have to follow our recommendation? The court has the authority to sentence you anywhere within that sentencing range I went over with you at the very beginning. Do you understand that?
Yes.
Okay. Do you understand, though, of course, that if the judge were to not follow the recommendation and sentence you to something else you were not expecting, you could withdraw your guilty plea?
Yes.
Okay. Now, do you understand that this particular sentence will involve a period of probation like we just talked about? But as part of that probation, Ms. Elliott, you understand that you cannot violate any law, not state, city, municipal, city, federal, no law whatsoever can be violated. Do you understand that?
Yes.
And you understand that while you're on probation, you have to follow all of the special conditions and all the general conditions of probation. But if you violate a special condition of probation, and that's proven to this court's satisfaction, and we meet our burden in proving that the court could revoke up to the balance of your sentence if you violate a special condition of probation. Do you understand that?
Yes. What are the special conditions of the probation?
It's actually not working for the state or state agency is the only one we're particularly recommending. Okay.
Okay.
Now, do you understand that you I understand you're requesting to be sentenced under a first offender?
Yes.
Okay. And so have you ever used first offender in the past?
No, I don't have a criminal history.
That's okay. And so you have no felony convictions, correct?
I do not.
All right. And Ms. Elliott, has your attorney gone over the pros and the cons of first offender, the good and the bad of first offender with you?
Not in detail.
Okay.
We just discussed the general provisions of it, but we have not gone over everything that probation would go over with her for first offender.
I'll cover it. I'll cover it with Ms. Elliott when it's my turn.
Okay, very good. Thank you, Judge. So, Ms. Elliott, last couple of things. Do you understand that you have a limited right to appeal because this is a guilty plea? Do you understand that?
Yes.
And have y'all talked about your appeal rights in this case?
No.
Okay, well, let's cover that. And the judge, I'm sure, will hit this as well. But do you understand that you, if you want to file a motion to withdraw your guilty plea, you only have up until the end of this term of court? Do you understand that?
Okay.
Okay,
Yes.
and that you have a limited amount of time to file an appeal from today's date. Do you understand that?
Yes.
Okay, and do you understand that if you want to, for some reason, say your plea was not voluntary, that you have to file a habeas corpus petition and that you have to file that within 4 years of today's date? Do you understand that as well?
Okay. Yes.
All right. And Judge, just in closing, the state is not aware of any warrants outstanding against Miss Elliott. She has been arrested, booked, and bonded out on this charge.
Okay.
And that is
all
all.
right. That's it. Great. Let me start with Ms. Jackson from pretrial. Good afternoon, Ms. Jackson. How are you?
Great, Your Honor. How are you?
I'm doing well. Tell me what you have in terms of criminal history for Ms. Elliott.
She does not have any prior arrests on file, Your Honor.
Great. That's consistent with what she said. Thank you so much. Ms. Elliott, I need to talk to you a little bit about first offender. First offender is primarily an opportunity, but it does carry some risks. You are eligible for first offender. Someone who does not already have a felony conviction can say, I'd like my first one, and this would be your first one, to be treated differently. If you are sentenced as a first offender, you will actually not have a conviction. You will be under sentence, but you will be what we call a first offender probationer. So if you are applying for a job or going back to school, and there's that dreaded question with the box next to it, have you been convicted of a felony? A truthful, correct answer is no, you haven't, because you're a first offender probationer. And if you successfully complete your probation and are discharged, you can not only have all this expunged, but it will continue to be the case that you are not a convicted felon, which is important in lots of professional ways and personal. If you want to vote, if you want to have a gun, things like that. So that's the benefit of first offender. You can actually accept responsibility for what you did and be sentenced, and it doesn't have that negative impact that a felony conviction can have. But there is a risk. I will likely follow this recommendation and sentence you to 7 years probation, but I'm going to hear from you. I'm going to hear from your lawyer before I decide that. If while you are on probation, there are more troubles for you, and just as an example, you get arrested for another form of fraud, not only will you have those new charges, but Ms. Dixon would be able to petition me to rescind your first offender status, and you will have already pled guilty. So there wouldn't be a trial. There'd be a hearing. I'd need to be convinced that you actually violated your probation. But if you did, then I could re-sentence you without a trial as a convicted felon up to the maximum in your case, which was the 45 years plus $1 billion or whatever the figures were. I'm not saying that I would do that, but I need you to know the exposure, because what I would likely do if a year from now we're together again and there was another form of fraud and it turned out that you really weren't done doing the things you were doing, you would probably go to prison as a result of your revocation here. And I'd have a lot of room to work with, not just the 7 years of probation, but the 45 years of your potential range. So there's a downside, but you control that downside, because if you're pretty sure you're done doing whatever happened in this case, then first offender can make a lot of sense. Do you feel like you understand the benefits of first offender and the risk of first offender?
Yes.
Do you have any questions about the things I just described to you?
No,
Do you want to be sentenced as a first offender?
I do.
Okay. Ms. Spearman, what do you want to share with me about the situation?
Your Honor, there's really nothing that I would like to share with you except that Miss Elliott, as soon as she was aware that criminal charges were pending and out there, immediately contacted an attorney's office, even when we were trying to seek a continuance because her attorneys were not available. She came to the court herself and presented herself for court. She is very open to providing restitution. I know that she's already spoken with me about here are my plans for how quickly I can pay it off and get it in. So we do believe that she is an excellent candidate for repaying restitution very quickly and for abiding by all conditions of probation probation and first offender status. I don't believe that she's a candidate who would commit any other offenses while on any kind of release. I know that I've been speaking with Ms. Dixon for a few weeks about this case, so it is something that we have been trying to resolve as quickly as possible. Ms. Elliott does work with mentally disabled adults, which is certainly no small task, and I believe something that only somebody of a really good character person can do, because I know that I certainly don't have the patience to engage in something like that. So I'm very impressed with people who do that type of work. And I think that she is an excellent candidate all around.
All right. Thank you. Ms. Elliott, anything you want to add? You don't have to say anything, but you've got the right to share anything about your situation.
No, I think I'm okay. Thank you.
Okay. Well, you're welcome. I've got a few questions. College educated, working, able to hire attorneys. Help me understand what was going on in this situation, because this was not one instance, but multiple instances of defrauding the government. So it's not something where I think someone of your training and education and intelligence could have thought it was an okay thing to do. And you did it for a while. What was going on? Why did this happen?
Just financial struggles where I didn't necessarily need cash money, but food to provide for my family.
How large is your family?
I have a family of 3.
Okay. And you were feeling stretched and times were difficult and that's what happened?
Yes.
Okay. All right. Well, it sounds like you are ready to return what you took and move forward with this. I do find that there's a factual basis for your plea and that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this, and knowing means you've understood all the things we talked about. Do you have any questions of me or of Ms. Spearman before I finalize this?
No.
Okay. I'm going to sentence you pursuant to the Probation Options Management Act, Ms. Elliott. And what that means is that while you're on probation, if you have a small violation, maybe you miss a meeting or something like that, you and probation will work through that. If it's a big violation, you're falling way behind on restitution, or you get arrested again, that comes back to me and we'll work through what the consequences are. Ms. Elliott, because you are at home and Ms. Spearman is at her office or wherever she is, I need to have the indictment signed virtually, as long as you sign off on that. Do you authorize my staff to sign the indictment indicating your guilty plea?
Yes.
Ms. Spearman? Yes, we do. And I do for my signature as well.
Great. And Ms. Dixon, do you authorize my office to sign your signature?
Yes, sir.
Okay. Ms. Elliott, I'm going to follow the negotiated resolution, and on counts 1, get the indictment back up here again. On counts 1 and 3 through 9, 1 and 3 through 9, your sentence is 5 years and it's probated. Count 2 is 2 years probated, but it's consecutive to count 1. That gets you 7 years. I will waive the fine. I will find that you owe $14,989 in restitution. And Ms. Dixon, that is payable to whom? We'll need to get that in the final disposition.
Yes, sir, Judge. And I can, of course, always put this in writing if the court prefers, but it is.
Why don't you do that? You can email it to Ms. Nelson, and that way she can cut and paste and get it right in there.
That seems to be the easiest thing, Judge. Thank you.
Great. So restitution will be payable to some state agency. Ms. Elliott, you do not need to pay that day 1. You do not need to pay it on day 10. We don't have debtor prisons here. If you are struggling to pay it because times are tough, that's okay. You will be paying according to your ability, which is one reason why the sentence is 7 years, which is a long sentence. If you pay that restitution off early, and everything else is going fine, I am happy setting a 3-year behavioral incentive date. 3 years from now would be March 23rd, 2026. So if in late March of 2026, you've taken care of your financial responsibility, this restitution, then probation is free to ask me to close out your case, and I will likely do that. There will be a special condition of your probation, and that is that you not seek employment with any state agency and you not volunteer with any state agency. And I am sentencing you as a first offender. Ms. Dixon, anything else on behalf of the state?
Judge, nothing further other than the last thing I think I should have already covered is making certain that Ms. Elliott understands that during the pendency of her first offender probation, she cannot receive, transport, or possess a firearm, and that is a crime if she were to do so. I think we're supposed to add that to our colloquy these days. So just making sure that is in the record. Ms. Elliott is aware that while she is pending probation on first offender, she cannot have a firearm.
It's a great point. So I mentioned that if you're a convicted felon, one of the consequences is that you can't own or possess firearms. That applies to first offender probationers. So I don't know if you're into guns or not, but if you are, you won't be for a while, because you may not have firearms in your house, in your car, anywhere near you, as long as you are a first offender probationer. Ms. Spearman, anything else on behalf of your client?
No, Judge.
Ms. Elliott, it sounds like you do very important work and care for folks who need that care. I wish you the best in that, and I hope that in the future, should you encounter some financial difficulties, you manage it in a different way. I'm sure this has been disruptive for you and horribly embarrassing for you. And I hope you're able to put this behind you as best you can, and keep doing the good work that you're doing.
Thank you.
All right, you all are free to go.
Thank you, Judge.
Oh, wait, not so fast. Ms. Tucson, can you please give Ms. Elliott reporting instructions?
No problem. Which county do you live in?
I live in Fulton.
You do live in Fulton? Okay. We gonna have your report. I notated on here on April 10th, 2023. And may I have your phone number so I can call you? I can also, I'm gonna email you the reporting instructions.
Okay. It's 404-451-6622.
Sorry, I didn't hear the last.
Can you say the number again, please?
404-451-6622.
451-6622?
Yes.
Okay, and then if Madam Prosecutor could send me the direct information for the restitution, that way I could include it with her packet. That way, when she starts making her payments to JPay, it will be allocated to the proper people.
Perfect. And Judge, may I get her contact information from your assistant, Ms. Nelson?
I can give it to you. It's no problem.
Okay.
Anyway, phone number 404-308-7618.
Okay.
And then email is Felicia, Felicia,
yes.
Tucson, TUSON @dcs.ga.gov.
Very good. Thank you.
All right, back to driving whatever truck you're driving, Ms. Tucson. You all are free to go. Thank you.
Thank you, Your
Thank you,
Honor.
Judge.
That wasn't your typical plea. All right. What else do we have to do? We have some bonds we could hear, some pleas we could take. I'm open to doing this in whatever order. Why don't we do this first? Let's figure out what we're doing with Mr. Dawson, because it sounds like it's not a plea today, and he and his lawyer can leave once I understand the plan and maybe bless it. And then I'm happy to do whatever you guys want to do next. So, Mr. Arca, what I understood understood was that there may be a way for this to sort out, and Ms. Willingham was open to consider it, but she understandably needed to talk to the alleged victim in the case. And until she could do that, she didn't want to commit 100%. And so people need more time.
Your summary and understanding is correct.
Okay, what is that thing?
So, Your Honor, they are asking essentially for a misdemeanor, and I did briefly speak with the victim about that, and I expressed to her that I am not 100% comfortable with that, but neither is she, and that reason being is because he is the father of her child. He does the income. I think she's more concerned about the loss of the job, which I do understand. So she asked if she had to give me a solid answer right now. And I did not want to force that on her. And I also expressed to her again that that's not necessarily the way that I want to go, but I am open to having the discussion and trying to work through it.
Got it.
So.
Okay. What kind of time frame?
Your Honor, I honestly think that, I'm sorry.
Your Honor, I spoke with Attorney Arca outside as well.
Okay, does Mr. Dawson have a second case, or you just guys are helping each other?
Helping each other,
Okay.
Your Honor, because I know that certain time is needed, and I knew that I was already going to take the plea for Mr. Loomis on April 11th. So my suggestion to everyone would be that I would stand in Ms. Willingham's place if she's not available on the 11th to take that plea.
Okay,
That works for me, Your Honor.
okay. April 11th. Why don't we, I'll get Ms. Nelson to let everyone know, okay? So the alleged victim in this case is the mother of Mr. Dawson's kid, hence the family violence angle to this. And she is going to think through if she's okay with a misdemeanor resolution. And I know she doesn't control it, but you want her input. You are going to be influenced by her perspective. Okay, and that's all reasonable, fair, and how it ought to work. Mr. Dawson, you're going to remain on bond in this case a little while longer, and we will see you here on the 11th of April with your lawyer, and we'll see if we're working the case out then. Okay, anything else? Okay.
Judge, may I have your excuse?
You may, and your client.
Thank you, Judge.
Sure.
Jasmine.
So, Ms. Wood, Ms. Primovic, anything in particular, an order you want to go? Should we do that bond hearing in the murder case?
I'm happy to do that, Judge. Also, my plea is ready on position 3, Mr. Crump. And
That's
then
good.
Ready on all my bonds.
Okay. Why don't we spring Mr. Abate? We'll do the arraignment and the bond hearing there. Then we'll take a quick break. You guys weren't supposed to be here till 3. You're bad with time, maybe because you've been out of the country. But let me do this bond hearing, and then we're going to take a quick pause. I had to meet with some of my favorite ADAs. Yes, we need to bring who is it? It is, hold that thought, Mr. How do we pronounce his last name?
I think it's Bryson.
Mr. Friesen.
Right.
Okay.
I'm not allowed.
Is this one?
Is that right?
Okay, I'll handle that.
Are you fine?
Mr. Abate, I'm going to ask again if, just wanted to confirm, if we go out with Mr. Lewis on Monday, that's not going to interfere with the conflict that you've shared.
No, Judge.
Okay.
At a later time, there's been a development that I was unaware of. I was speaking with the lead detective last night. He just started FMLA leave. His wife has an aggressive form of cancer, and they have 3 kids under the age of 5. So he is taking care of the kids. And since this is the beginning part of the treatment, it's pretty aggressive. So he's unavailable for a little bit of the time. He is taking, I guess the good thing is his leave, FMLA leave is intermittent. So I think once they get the first rounds of treatment under their belt, he'll be available well before the June. I think it ends June 30th, but he'll be available well before that.
Okay, but next week's not a good week for him and his family.
That's correct. They have a whole lot of appointments from what he has explained to me.
And you shared this with Ms. Feely?
I shared it with Ms. Primovic as soon as I found out today.
Okay.
No, that would be over our objection. We think that the client should be here, Ms. Feely should be here to have a motion on this. He's been in jail. He does, he can't even bond. She's ready for trial. And we understand, like, as a human, that's an awful situation. But maybe you could find someone to watch the kids for 3 or 4 hours in the afternoon to pierce him in, like, you will be, here on this time. So he doesn't have to sit around in the outside like they do. But
Okay. I hear both sides of that, and I won't leave everyone hanging. I'll let you know before the weekend starts how we'll manage it, whether we're going to get something on the record on Monday morning. But if it's going to be that, I'll let you know. I'm going to grant the motion, but I want you to be able, or Ms. Feely to be able to, I won't make you wonder over the weekend, well, wait, Lewis, Mitchell, what's it going to be? I think it is a valid concern. And I understand why the defendant would say, but I'm ready. So thank you for sharing that.
Yes, Judge.
You're still waiting for they went, okay. Is there? Okay. While we're waiting on that, what's happening with William Hill? That's not a bond, or is that a bond here?
They did. I don't know what they said about him.
Hold on a second, Vicky Purdue. Okay.
Judge, I believe that needs a conflict attorney.
That's what it would look like. Ms. Snyder was representing Mr. Hill. So he had a bench warrant. He basically has been scooped up. So.
And it looks like Mr. Franklin handled COVID.
Okay. Got it. All right. So we'll flag this and see what C3 lawyer gets assigned to it.
Position 7 is ready for this.
Good. Noted. We took one of those yesterday and then you left.
I was here.
Your client left.
Didn't take your kid.
I understand. And Tristan Swan, that's listed as a, wow, Dave Daring. I remember that goes way back. That's a probation revocation. Is that one we can resolve today, or is it going to need a hearing?
Right.
Okay. Holy moly. And then it's Bond, Sims and Wyatt. Okay. Got it.
And Judge, while we wait, position 1 furlough was not brought over, so I'll just get the waiver in.
Okay. So maybe we didn't get him back from Henry County.
He should be here. I did see him.
Okay. All right. But you'll still do the waiver. Thank you.
They coming up now.
I hear a lot of noise.
Yeah.
All right, Ms. Rivers, are you ready? This is position 5 on our plea and arraignment calendar, 23 SC 186080. And it is the state. How do you pronounce your last name, sir? Friesen. The state versus Xavier Friesen. And Mr. Friesen is charged with murder. We are going to handle his arraignment and talk about bond. Ms. Wood represents Mr. Friesen. Mr. Abate is here from the state. Ms. Wood, is Mr. Friesen waiving arraignment?
Yes, Judge.
All right, you'll fill out that paperwork. We'll get a scheduling order in place. Ms. Wood, tell me about Mr. Friesen, and I assume he's in no bond status and you'd like a bond to be set.
Judge, Mr. Friesen is 21 years old. He has been in custody 133 days in no bond status. We are asking the court to consider setting a bond in the amount of $100,000. He is 21. He's originally from West Palm Beach, Florida. He lives here. He has a lot of family support, as you can see on the Zoom. There's a number of, I believe, sisters and potentially mom is on there. He can live with his mother. She does have an Atlanta address. He has 2 children, ages 1 and 4. They're both local to Atlanta. He has a 10th grade education. And prior to this arrest, he was working at the airport. I believe this is his first felony arrest, Judge. So we just ask for the court to consider a reasonable bond.
Mr. Friesen, what were you doing at the airport?
Big back.
Say that again?
Digging back.
At the airport? Was it like there's a warehouse at the airport? Was it for a particular company or just general freight went through the warehouse? Okay. What was that company? Okay. Were you living with your mom at the time you got arrested for this? You weren't sure. Where else were you living? You had to think for a minute about where you were living at the time you got arrested. Were there other places you were living?
Yeah, I'm spending the night, yeah.
Okay. All right. Ms. Jackson, can you share with me the criminal history information you have for Mr. Friesen?
Yes, Your Honor. The defendant has 6 cycles. The defendant's last arrest was December 3rd, 2021 in Clayton County for aggravated assault and criminal trespassing. The defendant does appear to have several open cases pending. One for simple battery, that's in Fulton County. The case number is 21 CR 00711-2 and the letter J. And there's one for simple battery and simple assault. That case number is 19 CR 00812-2 and the letter J. And there's an open case pending in Clayton County for aggravated assault and criminal trespassing damage. Nothing in addition, Your Honor.
Thank you so much. Mr. Abadi.
Thank you, Judge. The state would respectfully request that you deny defense counsel's motion for bond for several reasons. First, the state would submit to the court that the defendant is a risk of flight in the sense that, as you've heard today, his ties to the community are not, he's got very little ties to the city of Atlanta. It sounds as if. It also sounds as if the defendant doesn't have a stable place that he was staying at the time of this homicide. I'd also submit to the court that he's a threat or danger to the community and the people in it based on the facts and circumstances of this case. On November 10th of 2022, he did open fire in the middle of an apartment complex here in Buckhead in the middle of the afternoon. It was around 4:30, shooting the victim, Mr. Marks, 8 times. The strength of the case is pretty great in the sense that the entire incident was caught on high definition video surveillance from the Amelie apartment complex, where you can see the defendant as the defendant and the victim are speaking. The defendant decides to shoot over the shoulder of a actual resident or employee, excuse me, of the Amelie apartment complex through the door and shoots the defendant, or excuse me, the victim 8 times. I'd also submit to the court the defendant is a risk of committing felonies pending trial based on what Madam Pretrial Officer was explaining to the court at the time of this incident. He was on bond for 3 cases, 2 out of Fulton County, both simple battery. The most recent simple battery involved him punching 3 females at the time of the incident because he had gotten angry. He seems to have a pretty serious anger problem that kind of erupted on November 10th. He also was on bond for a Clayton County case, aggravated assault, Your Honor. All 3 required that he not have any firearms, is my understanding. And I would also submit to the court, he's a risk of intimidating witnesses, as he did open fire at the victim in this case in front of several eyewitnesses, one being the girlfriend of the victim in this case that he had known for quite some time, based on the relationship that he had not only with the victim, but the victim's girlfriend, Your Honor. So based upon all that, I would respectfully request you deny defense counsel's motion for bond and the defendant remain in the custody of the Fulton County Sheriff's Department.
Mr. Marks is the deceased. You're saying Mr. Marks's girlfriend, or it was Mr. Fryson's girlfriend who was present at the time?
Both Mr. Marks's girlfriend and Mr. Fryson's girlfriend were both present and watched the shooting as it went down, Your Honor.
Okay, got it. Okay. We'll keep coming off mute. Mr. Fryson, you've got 2 kids. Are they in the Atlanta area or are they back in Florida? When did you move from Florida to Atlanta?
13, 14.
All right. Ms. Wood, anything else on behalf of Mr. Fryson?
Trying to just let the court know he has no issue. If the court is inclined to set a bond, he would be compliant with an ankle monitor and all of those stringent conditions if the court sees fit.
Okay. Mr. Abate, Mr. Fryson is being arraigned today, so discovery is due soon. Do you have a sense of how voluminous, complex, we're going to miss this, it's going to take a while to get that? I know ballistics take a while, but setting that aside, how readily are you able to get to Ms. Wood the discovery that you have? And then are there big pieces that are missing? We know there's, you described surveillance video. I trust you've got that and that can be handed over.
Yes, I can hand over the majority of the case file to Ms. Wood by either Friday afternoon or very early Monday morning. I can make sure that it's electronically transferred to her. I also, ballistics are something that obviously are pending. They are with the GBI and hopefully the testing of that would be pretty quick. But I would, ballistics in this case are less important in the sense that it was caught on very high definition camera.
And the record, as you understand it, are there multiple guns being fired or just one?
It's just one gun. The defendant, Mr. Friesen, fired 8 times at the victim.
Okay. You said you'd be able to provide the majority of the file. You can't provide ballistics yet because they're not complete. What else would not be ready?
I think that would be it. There may be some testing done by the GBI for DNA and things of that nature. And I say that I don't want to commit to that because I'm not 100% positive, but I can give her the entire case file from the Atlanta Police.
Other than GBI results?
Yes.
And the things that would be tested for DNA are already with the GBI, or they're things that you hope to obtain and submit?
They're with the GBI. It was the firearm. I think it was sent to the GBI, but I would have stated to the court again, the DNA is not that important in the sense that you can see the defendant firing the gun that's being tested for DNA.
Okay. All right, Mr. Fryson, I'm going to leave you in no bond status for right now, but I'm going to ask Ms. Wood to, and I know she will, but I'm going to ask anyway, to bring to my attention if this case is delayed for any reason that's not a delay that the defense wants to have. In other words, if discovery is slow or their witness names but not contact information, anything that slows Ms. Wood down from being ready to say, let's go to trial, that needs to be brought to my attention and we will revisit the question of bond. But based on the fact that you were on bond on 3 separate cases, all of which have allegations of violence, and all of which would have carried with them at least the bond out of Clayton requirement that you not be around guns. I think that leaving you where you are is safest for you, as well as other people involved in the case and the general community. So I'm going to keep you in no bond status for now. I am more than willing to revisit it if we get knocked off the schedule that will be entered in the next couple of days because of something that's going on the state's side of things. All right. That's it. Thank you. All right, we're going to take a 5-minute break. When we get back, if you all can scare up Mr. Richardson, we can take that plea. Otherwise, we'll do more of the bond hearings or the plea, Ms. Wood, that you've lined up.
And Your Honor, I'll be covering for 88. I'll be taking please move forward.
Excellent. So we just need to find Mr. Richardson. I'm going to meet with these two gentlemen in the blue blazers back in the jury room.
Yeah.
Thank you.
I guess they require. So it can be a good or bad thing for both of us.
Thank you.
But you I'll leave off.
Where's Miss Williams? Yeah.
It makes every time he's like, no, hey.
No, I'm just throwing out numbers to help, pretend to help.
If you think I would strongly consider it just wouldn't be a straight approach. Yeah. Something around 20 September.
I'll tell you.
Okay.
Thank you, Alex.
You're welcome.
Thank you, Lacey.
Yes.
Yeah, I'm in the building.
Thank you.
I don't think the case is as bad as they think. Mr. Lewis's case? It's not bad. 10 on the, we're giving 10 on the server.
Is that your office?
10, he's got 4 times the phone. He doesn't know. I know he's great. I'm not questioning him. But he said they'll hire him. Who's showing 6 numbers? 6.
The last one is working.
So, and he wasn't armed. Which was, the murder. And that's his house. The defendant's house, not position. Article's crazy. That, to me, I don't. She's so mad at us.
Yeah, Katie. Oh.
It's a light topic. Crazy number. You did? So he good? He wanna talk? He was talking crazy?
How's he gonna not?
Y'all done? $82 rules. How many you need? You need some drums.
We could take one, we got one to take down.
When you get like 2 or 3.
I know. But I mean, it's a lot. I'm not risking. He's risking it all. If he gets might go up more, no matter what. I miss Miss Patel. She had the right idea. How is she?
She's so good.
Where is she? I think she's working on it.
Yes. I don't know. That's a good question. No, she's really. And golf. Yes, she's really good though. She got married.
Oh, she did? Well, that's great. They still live kind of like over by
Yeah.
Cabbage Town.
Yeah, they're over there. I'm gonna see her this weekend. I'll
That's
tell you
how I
ask her down there. Yeah.
I miss her.
Me too.
And then who was trying to?
But I just got an email and I was like, what is this? What kind of case was that? Was it murder? Oh. Oh.
Yeah, it was like.
Oh, this is the one that was.
Yeah. So near the vortex.
Okay, that's a little fun.
Is that what's up here?
Just regular fun.
Okay. There we go. I don't take mine very often. Oh, but yeah, who sounded like
It was Jenny.
because it was the same two in the shop. Like the outside of this Megan did most of the stuff.
So that one where like a plea was put up and
Because I really, she's very strict.
oh, okay.
So by Friday, yeah, it's a way to teach them. So hopefully that our side, you know, it's offer probation on Thursday, not Monday. So I think
Wild.
that's the only one.
What? I think, yeah, no, that is, you're done. Yeah, you're done except for whatever.
I don't know what's that guy. I didn't know about this. Oh my God.
Here.
Was he like, did they all sleep together?
Sure. I'll disappear, man. We go tomorrow, right? Well, you don't like. I'm getting it from the naysayers.
Until they have to tell me specifically.
Yes.
Yeah, they say, I just asked her to be off. I'm like, you just said. They trying to cancel us and go.
We said we got people. I said, all right, claim. I said, listen. I'm like,
Okay, I'll stay over here. And so they come to me and text my phone.
so everyone said, go with that negativity.
And look, you gonna come to work now?
So that's like a mess. No.
I'm from the supposed to training. Yeah, unless they text me, they can come to work. And then I asked him, what is that about a roll call?
I did. I went in Monday, Tuesday. I did this.
So I don't know. That's all I do to myself.
I was there too.
Court come to order, remain seated.
You okay? It's dramatic. I come in and you sigh. Just like the Beebster. All right. Are you ready? Ms. Castillo, come on up, please.
You know, man, she's not cussing.
This is position 7 from our truck. Yes, so I need to make a note about, just before you go, where did that go? Jumel Lewis, who's the detective?
Gordon Payne.
P-A-Y-N, P-A-I-N. P-A-Y-N-E.
I can email your honor as well as and CC Ms. Feely his actual FMLA lead form that we had.
Just do that so we have a more complete record. And then as I promised Ms. Primovic as Ms. Feely's agent, at a minimum, if she wants to get something on the record, we can do that Monday morning. I don't know that we'll all reconvene tomorrow, but I want to let you and Ms. Feely know before close of business tomorrow what I'm doing with that, so that you're not spinning, she and you aren't spinning your wheels on that. And he's not just, hey, I picked up shell casing. He's the lead detective. And I'm comfortable doing this because Ms. Wood is right here. This is a case where the lead detective ties up a lot of loose ends, or does the lead detective say, I'll press play on the confession, and Mr. Lewis says, I shot him 10 times in the head?
He ties up a lot of loose ends. Mr. Lewis doesn't make a statement.
Okay. All right. Well, if you would please get that email to me, Ms. Nelson and Ms. Feely, that'll be my reminder to at least via email, get something out to you all. And then more formally, I could enter an order so that there's something, should there be an appeal, that the defense could point to if I grant the continuance.
And I will file a more formal motion Saturday as well.
Okay, thank you.
Thank you.
Okay, ready, Ms. Rivers? This is position 7 on our trial calendar, State versus Jessica Castillo, 22 SC 180351. Ms. Castillo is here in court with her lawyer, Mr. Richardson. Mr. Jordan is representing the state on this, and it's my understanding that we have a negotiated plea or close to negotiated.
Negotiated, please.
All right, we've got a plea.
Yeah, please. It's worked. It's almost worked out.
All right, Ms. Castillo, you've now seen several pleas since you've been sitting in court yesterday and today. It's your turn. Mr. Jordan's going to put you under oath in just a moment. You'll provide truthful and complete answers to all questions after that, and you will let Mr. Richardson or me know if you've got any questions of your own so that I can be comfortable that you have understood all the things we've been talking about. Is that correct?
Yes.
Excellent. Mr. Jordan.
Your Honor, I have Ms. Castillo's plea of guilty statement here.
Great. I'll take that.
And just to make sure, this is a plea to counts 4, 7, and 8. Is that correct, counsel?
That's correct.
Okay. And the state will dismiss the remaining counts, Your Honor.
Okay, let me just pull up you keep going. I'm going to pull up the indictment.
Okay, thank you very much. Ms. Castillo, can you please raise your right hand? Do you swear or affirm that the testimony you're about for the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name?
It's Jessica Van Castillo.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there a medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone to school?
42 in college.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have been charged with the offenses of aggravated assault, burglary in the first degree, and possession of firearm during commission of a felony?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes.
Have you had enough time to speak with your lawyer? And I apologize, I know it's Mr. Richardson, but if you.
Ricky, Rickey.
Mr. Ricky Richardson, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss the case with your attorney?
No.
Are you satisfied with his services?
Yes.
Mr. Richardson, do you waive formal reading of the indictment?
It has been read to her. We waive for the purpose of this plea.
Do you also waive any and all defects in the indictment?
Yes, for the purpose of this plea.
You go.
Yes.
Sorry.
It's not a problem, Ms. Castillo. This is a difficult event.
And I can definitely pause, Your Honor, if Ms. Castillo needs more time.
I was gonna wait till we got the tissues, and then I was gonna ask her, are you okay going forward right now, or do you need a minute?
No, I'm okay. Thank you.
Okay, if you need to pause, that's all right. I promise we won't say, oh, you have to wait 2 hours. We'll just
No, thank
give you a minute to collect yourself. All right, let's keep going.
Ms. Castillo, do you recall having been arrested on these charges?
Yes.
Your Honor, the state is unaware of any outstanding warrants that are related to these charges. Mr. Richardson, do you know of any outstanding warrants that are related to these charges?
I'm not aware of any.
Ms. Castillo, has your attorney advised you the minimum and maximum sentence for each charge that you were pleading to?
Yes.
And just for the record, Your Honor, for aggravated assault, the minimum is 1 year and the maximum is 20 years. For burglary, it is the same minimum of 1 year and the maximum of 20 years. And possession of firearm during commission of a felony is 5 years consecutively, statutorily. Ms. Castillo, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, as previously stated, the state is dismissing all counts except 4, 7, and 8. On counts 4 and 7, the state's recommendation is 3 years probation. On count 8, the state's recommendation is 5 years suspended to run consecutive to counts 4 and 7. I understand that Mr. Richardson is going to ask for a different recommendation, but was that the negotiated recommendation that was communicated to you, Ms. Castillo?
Yes.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes.
Are you currently on probation or parole?
No.
Do you understand that since you are being placed on probation, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
Do you understand that your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, and finally, your ability to obtain employment?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in the commission of a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you were giving up the following rights, which I will now list off? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No.
And it's my understanding, Attorney Richardson, that she intends on entering a plea under North Carolina v. Alfred. Is that correct?
That's correct.
Are you pleading guilty under North Carolina v. Alfred because you have decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
Ms. Castillo, how do you plead to the charges of aggravated assault, burglary in the first degree, and possession of firearm during commission of a felony in indictment number 22 SC 180351?
Guilty pursuant to the offer law in North Carolina.
Thank you. Is this guilty plea under North Carolina v. Alfred freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that since these are felonies, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
And Mr. Richardson, have you advised to Ms. Castillo her deadlines for filing a direct appeal? And Your Honor, for a factual basis, if this case had gone to trial, the state believes it would have been able to prove beyond a reasonable doubt that officers responded to a person shot at 1677 Dorsey Avenue in East Point, Georgia. Upon arrival, officers observed 4 holes in the door, and the doorknob was on the ground near the front door. Mr. Victor Castillo stated that he was asleep in his home when he heard a knock at his front door. As he approached the door, he heard someone state that they were the East Point police. He then slightly opened the door and saw his wife, the defendant, at the front door. She was with her boyfriend, known as Sweetie. Victor stated that one of the two then shot through the door twice, and that he was shot on the left side of his chest. I do believe yesterday, Your Honor, that it may have been stated that he was shot in the stomach. He then attempted to run to his bedroom to hide, but Sweetie told him to get on his knees. Sweetie then put the gun to his head, and when the gun was pointed to his head, Victor Castillo stated that he asked his wife why she was doing this. There was a bag that contained car keys and other personal items that was taken. Victor Castillo then did state that the two left the apartment, but returned a short time later and fired 2 shots through the door. That does conclude a factual basis for this plea, Your Honor. Your Honor did hear the exact same facts or similar facts yesterday in regards to this plea. So Your Honor is very well aware that Mr. Castillo is currently serving a sentence in federal custody, which is, I believe, 15 years. So the state would ask that you accept this negotiated plea. We understand that this is a very difficult situation for Ms. Castillo. So we would ask that you accept the negotiated plea so perhaps they can move on from this event.
Okay. Ms. Jackson, do you have any criminal history information for Ms. Castillo?
It's Miss Castillo from the calendar from yesterday.
Yes, ma'am. Position 7 from yesterday's trial calendar.
Okay. The defendant has 11 cycles. The defendant's last arrest was November the 29th, 2022 in Henry County for obstruction of an officer and criminal trespassing and interference with government property, 2 counts. There was no disposition for that arrest. The defendant does have 1 prior felony conviction out of Henry County. It was in 2016 for aggravated assault. Nothing in addition, Your Honor.
Thank you. Ms. Tucson, is Ms. Castillo on probation for that Henry County case?
She's not on active probation.
Thank you. Okay. Mr. Richardson.
Yes, Judge. As court knows, Ms. Castillo is 42 years of age. She's a high school graduate, as well as she attended trade school and has a dental technician certification. She has 3 children and 2 grandchildren. She was married to Mr. Victor Castillo for 22 years. And to describe it as tumultuous would probably be an understatement. They originally moved here from Chicago for a better life, and just the opposite has happened. He's picked up, I believe, a drug charge as well as a 924 charge for guns. He had some perjury charges. He attempted to contact me early on in this case. At that time, he had not been sentenced. He called and said, "Hi, my name is Victor Castillo, blah, blah, blah." And he wanted to talk about her. I said, "Well, talk to your federal defender, and then we'll do this the right way." In any event, ultimately, he sent me, and I believe Jay App, a letter exonerating Ms. Castillo, as well as I believe Mr. Santiago Cano, the gentleman who took a plea on yesterday. She was in custody, Judge, for 6 months before Your Honor allowed her out. I don't have the exact dates and times, but I certainly can pull those up. And then after that, she was placed on an ankle monitor for now another 2 years.
So she's still wearing it?
She's still wearing it
Okay.
as of now. She paid for it up until the point where her house burned down.
Oh, right. I remember this.
The court allowed the county to pay for it the last couple of months. Her house is, found another reason she left yesterday, because the contractor who was supposed to do work on her house finally showed up. Her house also got hit by a tornado. And so she's got 2 claims running. They have been in temporary housing as well as with her mom. So it's been a lot for her. She is a single mom now, effectively, because Mr. Castillo is away for the next 15 years, less whatever good time or whatever. Judge, she enters this plea on the auspices of Alfred versus North Carolina. There is a defense in this case. Obviously, Mr. Castillo wouldn't be much help to the state, but I did explain to her, and she understands party to a crime, explained ad nauseum that juries don't always do what we think they're gonna do. He may take the stand and says, well, I was on high, I was on drugs, and they may discount it and say, no, what you said at the beginning is what occurred. And so we're gonna ride with that, we're gonna just throw it away.
Sure. No. I mean, there was a fairly detailed description of what happened. And there are lots of reasons the state could point to, afraid of becoming a snitch, even though he's the victim as opposed to snitching on people, not wanting to get his former wife in trouble that you would have to navigate in defending Ms. Castillo. And if the 2 dismissed charges were still in the mix, you hit well, but you don't hit 1,000. And so if this is one that didn't work out for Ms. Castillo, it's at least 10 years away from her kids and grandkids.
Absolutely, Judge. And given her mom is not in excellent health, that she has a 20-year-old, 22-year-old, I think a 12 or a 14-year-old, and a smaller child, and 2 grandchildren rely on her, it's in her best interest to tender this plea. You see, she's very emotional about it. She maintains some innocence. I did listen to the videos. I did watch the videos of surveillance. There appeared to be a woman who was blonde. Now, of course, we can change our hair color rather, but what I have also is her mugshot the next day. Not to say she didn't go home and wash it out and turn it back to her natural black, but that is something that we could argue. She was not, even per the state's colloquy, the possessor of the firearm, but again, party to a crime, aid, abet, counsel, coerce, etc. She certainly could be found guilty of aggravated assault, home invasion, burglary, and she'd have a much more serious event. The reason and I'm going to ask the court to sentence her to 2 years probation as opposed to 3 is because the terms and conditions, I believe, of Your Honor's ankle monitor was hospital, court, I think maybe
and work.
And to work. And that's for the last 2 years what she's been limited to. She couldn't go to kids' school events, etc. Plus the 6 months that she served in custody. She will still have a year and a half, or almost 2 years. And she understands, though the 5 years is suspended, it's kind of a ghost hanging out there. And if something should go awry, then that would come back to life and bite her like a shark. So that is my request. And she tenders this plea under Alford versus North Carolina. We ask the court to accept that. And that is all, Your Honor.
All right. Ms. Castillo, what do you do? What is your line of work?
I'm a dental assistant.
Oh, hence the certification you received. Is that the same?
She also has an opportunity to work at a restaurant once she's available.
Okay.
So,
is a dental assistant the same as a dental hygienist?
No, it's not, but we work hand in hand with the dentist, and pretty much the hygienist is just a notch above us.
But if I went to where you work, would you be poking things in my mouth, or
I definitely will. I will not give you anesthesia, but I will be suctioning your.
Okay, so you're in the mix.
Correct.
Making my life unhappy in the dental chair.
I'm going to give you comfort.
Okay, you give me comfort. I appreciate that. Probably wouldn't be appropriate for me to go to the dentist where you work, but that's all right. It's not personal. You were married to Mr. Castillo for 22 years.
Correct.
Any reason you can think of that he would say not only that you did this, but that you and Mr. Santiago Cano, did he know Mr. Santiago Cano?
For the most part, my husband was always cheating. This is not the first time he accused me of an accusation. And from what I understand, the gentleman was dating or had a relationship with Victor's current girlfriend that
Mr. Cano did.
I believe so, yes.
Okay, that's how they would have had hostility.
Yes. So other than that, I wouldn't know.
Did you know Mr. Cano?
I didn't know neither the girlfriend nor the gentleman.
Okay, meaning the girlfriend that he and your husband shared.
Correct.
Okay, all right.
As an aside, she's saying that there was some cheating a couple of different times.
Yes.
She's come home with the kids.
And he's
been in the basement naked with another woman. And it didn't. So they've had, like I said, to call it tumultuous would be an understatement, but
yeah.
But all the Brody details.
You have an aggravated assault out of Henry County. What was that about?
Victor lied to the officers, said that I beat up or shot at his girlfriend, and I had a permit, a license to carry a gun, and he was having sex with her. So he gave the police the gun, and then I went to court, and the lawyer called my husband's phone and told him that I had court, and my husband didn't tell me, so they arrested me and they offered me a plea. I was scared and I took the plea.
Got it. But this is another one of the scenarios where.
That's the first, yes.
Okay, you caught your husband at home with
Yes.
someone not named Jessica Castillo.
Correct.
All right. All right. You understand that an offered plea, which is what you want to do, I can accept, and I understand why you're pleading under offered, and I'm going to accept it under offered, but it still shows up as a conviction. It's not like a NOLO, it's not invisible ink or anything like that. You already have a conviction, so this isn't going to materially change, hey, can I get this job or that job? You've already had to check the box of, I've got a felony, but I want to make sure you understand before we go any further that it still shows up as a conviction. You understand that?
Yes.
Okay. The aggravated assault you're pleading to, given your former relationship with Victor Castillo, actually has a range of 3 to 20. It's not going to change anything I do, but I want the record to be clear. It's not 1 to 20, it's 3. I actually could not give you a sentence of less than 3 years. Your lawyer has asked for more than 3 years anyway, with the suspended part. But just so we're all clear, 3 is the minimum for aggravated assault where the victim is a spouse or former spouse. It's all right, wasn't your case. Ms. Castillo, I do find that there's a factual basis for your plea. That's not me taking sides and saying I believe Victor or don't. It's exactly what Mr. Richardson said. A jury could hear all of this evidence and say Mr. Castillo was at his most honest when he first talked to the police. And he's had a million reasons to change his story since then, whether it's threats or remorse or whatever it is. So I don't know what a jury would do, but because your lawyer doesn't know what a jury would do, he's probably advised you to go forward in this way. And I do find that there is enough evidence that the jury could credit. I also find that your plea is knowing and voluntary. It means no one's forcing you to do this, and that you've understood all the things we've talked about. Is that correct?
Yes.
All right. I'm sentencing you under the Probation Options Management Act. And all that means is that if you have any problems on probation, and I hope you don't, if they're small, you and probation work through that. If they're big, you get arrested again, something like that, that comes back to me and we'll figure out what we're going to do. Do you authorize my staff to sign the indictment indicating your offered plea to counts, whatever they are, 4, 6, and 8?
4, 7.
Yes. 4, 7, and 8.
Yes.
Okay, Mr. Richardson, can we sign for you?
Yes, sir.
And Mr. Jordan?
Yes, sir.
All right. And I've got a plea form where Mr. Richardson covered with you a whole bunch of rights. You put a little JC next to a lot of them. And it basically explains how this was supposedly going to go. Did you sign that? Is that your signature on page 4? And Mr. Richardson, you signed it as well? All right. So what I'm going to do on count 4 is sentence you to 3 years to serve 3 months with the balance probated. You've already done 3 months. You did a little less than 6 months. I had to take you did 147 days. So it's 4 months and some change. So I'm sentencing you to 3 years to serve 3 months, balance probated on count 4. And the same sentence on count 7. They'll run concurrently with each other. And then count 8 has to be 5 years, has to run consecutive. So it's a total sentence of 8 years. The first 3 months you would serve, you've already served them. Then there'll be 2 years and 9 months of probation, and then 5 years suspended. I will set a behavioral incentive date of 2 years. So in late March of 2025, probation needs to look at your situation. If you've done everything you were supposed to do, all is going well, they should reach out to me to say, can we close this out? And I will say yes. So there's a reason to do what probation asks you to do. I don't think you asked for any special conditions. in Mr. Cano's case, there was no contact with Ms. Castillo and no contact with Mr. Castillo. I'm going to impose one of those two. You should not have any contact with Mr. Santiago Cano. I don't necessarily want to say no contact with Mr. Castillo, although he's going to be locked up the whole time you're under sentence. And so I don't mind saying that, but I don't mean to make complicated anything that's going on with your kids and your grandkids and whatnot. Do you have a perspective, Mr. Richardson, on that?
For the last 2 years, she's washed her hands with him. Last 2 years when he's called, the kids answer the phone. I guess they get that special chime.
Yeah.
Says, this is from the prison. She wants nothing to do with it.
Okay, then let's keep it that way. So no contact with either your co-defendant or Victor Castillo. And I think that's it. Anything else, Mr. Jordan? Mr. Richardson? All right, let's get Ms. Tucson to weigh in. What county do you live in?
Henry County.
Henry County. All right, Ms. Tucson, we've got a soon-to-be probationer who lives in Henry County.
Okay. First thing is, I believe one of their offices out in that area closed. So I'll have to call you directly. Do you have a phone number that I can call you? And then I could also get this over
Yes.
to your attorney. What's your phone number?
It's 773-569-7294.
Yep, that is Chicago.
Yes.
73. Okay, and then 773-569-7294. And so you'll need to report within, it's gonna be 2 weeks because we have to, I don't know what's going on with Henry County, but if is it Richardson?
Yes, ma'am.
If you could send me an email, and that way I could also email Ms. Castillo's reporting instructions to you.
All right, can I get an email address or should I'll give you my email address. It's simple. It's rlrlaw01@gmail.com.
rlrlaw01@gmail. Okay, I will be reaching out to you, and report date will be April 10th.
Thank you. Judge, this being concluded, then the ankle monitor, she authorized to have that removed then?
She is. I don't know how that works. I know it happens. And so A&A is the monitoring company. Contacting them is the best way to do it. They may come to you. They want their merchandise back. You may need to meet them somewhere. But that's, I think, who removes it. Ms. Wood, have you had?
I was gonna tell him, there's a lady that coordinates, is it a county funded ankle
It's
monitor?
county funded now, yes.
So yes, so there's someone from our county that needs to also coordinate. I can send the information to you if you'd like.
Okay.
You got my email?
What is it?
It's RLR, my initials.
Okay.
The word law, 01.
Got it.
As you know.
So that thing's coming off in the next few days.
Thank you.
All right. You get rid of that tan line.
Absolutely.
All right. If there's nothing else, thank you, Mr. Jordan, for stepping in. Thank you, Mr. Richardson, for pushing on this one. Good luck, Ms. Castillo. You got a lot of folks who depend on you, and it sounds like you want to be there for them.
Absolutely.
All right. Take
Have a
care.
good one. Thank you.
Concludes my business, my big excuse.
Yes, sir.
Thank you, Judge. Good to see you all.
Same. So where does that leave us? Dawson didn't plead. Back to this calendar. Ms. Wood, it's all you. You want to do Mr. Crump's plea? Do you have people who've been waiting? We have people in court. If they're here for a case,
We're here for Mr. Swan, so I'm happy to do that with you.
let's do that. So we can get them on their way. Just need to find that calendar. So if we could have Tristan Swan, please. Great. Let me see if I can find that. Remember that. Oh, there it is. Yay. Way to go, Ms. Nelson.
Okay, that's what I'm saying.
Mr. Swan, you could, when you're directed, you can sit right next to Ms. Wood. All right, Ms. Wood, you ready?
Ready, Judge.
This is position 5 on our bond hearing calendar. It is 05 SC 25952, State versus Tristan Swan. Mr. Swan is on probation in that case for aggravated assault and robbery. And I signed, everything in this case is old, a warrant in July of 2020. The allegation in the warrant is that Mr. Swan committed a new crime while on probation for this old crime. And that was specifically burglary and having a firearm and possessing a firearm during the commission of a crime down in Polk County. I say down, I don't know what direction Polk is. Is it south? West. Over in Polk County. In February of 2020, so over 3 years ago. And this has caught up to us now. Mr. Swan's been in jail for, looks like a couple weeks. And we need to figure out what we're going to do. First, let me find out from Ms. Tucson, how much time remains on this 05 case?
It is 3 years, 4 months, and 18 days remaining.
All right, that's an enduring case. Thank you. Ms. Wood, is Mr. Swan admitting to this allegation that he was arrested in Polk County 3 years ago for those things?
Yes, Judge. If I could just clarify, I do have the petition for the Polk County, and there's, I guess the Clayton County. There were 2 different arrests that I was aware of. So I just want to make sure we were taking care of both of them.
I want to take care of everything. And maybe there's more than one warrant. The warrant I have was one signed in July of 2020. And the only thing listed on it is the Polk situation. But he could have more than one warrant.
Okay, so and then I have this petition that looks like it was just filed. Yes. Yes.
Okay, you'll see on the screen, that's what I've got. Thank you. Oh, look at that. 3 years later, I signed a petition. Okay, so this is more complete. The February 2023 petition that I signed has the Polk arrest, and it also has an arrest in Clayton County from just January of this year, false imprisonment, family violence, battery, aggravated assault. So it's a little more complicated than what I have on the screen, which I will now take down. We ought to deal with both. 2 different criminal allegations, one old, one fresh. Is Mr. Swan admitting he was arrested for both of these? Hopefully there's closure on the Polk one and we can say this is what happened. The Clayton one, it's got to be pending still, but let's see.
So yes, the Clayton County is still pending. He's out on bond for that, or he was released directly here once bonding out. And then I believe the Polk County one sounds a little more complicated. It's still open. Apparently the co-defendant on that case is now deceased. So I'm not sure how Polk County is making their way through their backlog, but that one is also still open, Judge.
Okay. So what is Mr. Swan? Is Mr. Swan wanting the state to try to prove up either? They'd really only need to prove up one of them, either the Clayton situation or the Polk situation, or is he admitting for purposes of revocation these?
We're admitting, Judge.
Okay. And what is it that you are recommending?
Judge, we are asking the court to consider revoking for 60 days and considering closing out. This is a very old case. He tells me that these two incidents are his first time interacting with the system since being on probation. I'm sure Ms. Tucson will help us confirm that. He was arrested in January in Clayton. He sat there for a month or a little over a month, and then he was brought here. So he's been here since February 20th of this year. So right at 32 days.
But he's been in custody continuously from the 26th of January.
Yes, Judge.
Okay. All right. And who is the alleged victim in the Clayton case? Someone here in court. Okay. And what relationship is that person who raised her hand to you?
She's a good close friend, girlfriend.
Okay. I mean, you might want to get it right since she's sitting here in court. Okay. Do you all have kids together?
No, sir.
Okay. But you had been in a relationship. Okay. Well, that's not, it takes two people to say they're still in a relationship. I don't want you to talk about what supposedly happened. I just needed to understand the dynamics here. Okay. And then the situation down in Polk, that's not a intimate partner situation. So I don't want to hear about the Polk thing. Ms. Tucson, I don't know where you are. Do you have access to, it used to be called Scribe or something like that, but the probation system to see how Mr. Swan has done? He's been on probation for a long time. He was sentenced in 2006, and he is saying through his lawyer that all went well until Polk, and then things went well until this Clayton arrest.
I have Portal pulled up. That's what I can look at. If you give me just a few moments, I'll go through and see if there's any old warrants, dockets, reports, things to that nature. Just give me one moment.
Sure. While she's looking that up, Mr. Jordan, tell me your thoughts. These are two serious sets of allegations. The defense is asking for 60 days, which would be basically let Mr. Swan out now because he's been in for 60 days. They are only allegations. The Polk one sounds complicated, and if it were real urgent down there, maybe something would have happened with it by now. The more recent one is complicated because it involves intimate partner violence allegations, and we've got the alleged victim here in court. So I want to be thoughtful about this, but I want to make sure if the state wants to try to prove some of this up rather than say, yeah, just 60 days, they get that chance.
Your Honor, the state would, our recommendation is to revoke 6 months county time. I will be candid with the court. I was not aware of the Clayton County arrest. I was only working off of the old warrant that had the Polk County arrest on it. Nevertheless, Your Honor, we do understand that this is a 2005 case that he was on probation for. We do understand that it is still substantial to be arrested, especially twice, and bringing him here on his revocation today. So our recommendation, Your Honor, would be to revoke 6 months and then suspend the balance, given that it's such an old case, and the state doesn't see the point of continuing to monitor him, given that it's almost 20 years since the incident.
Okay. Ms. Wood, do you know, I can't remember what you said about, did Mr. Swan make bond in Clayton County? And if so, what are the conditions of the bond? Because I don't know that I would suspend the probation, given that there is this Clayton case. To me, that's a reason to have another set of eyeballs on Mr. Swan until the Clayton situation is resolved. But then I'd want the conditions of probation to mirror the bond conditions. And if the bond out of Clayton says Mr. Swan's not supposed to have contact with the young lady here in court, then I would want to echo that. If for some reason that's not the condition of a bond, then I wouldn't want to impose one contrary to what the judge down there did.
No restrictions? Okay. Okay, Judge, he tells me that there is no bond condition where he's not supposed to have contact with her. I do know that I've had lots of contact with her and.
Can I have a last name of her?
Ms. Anderson.
Ms. Anderson, great. So you and Ms. Anderson have spoken a fair amount.
She's also spoken to probation quite often.
Okay.
And so he tells me that there is no bond condition, Judge. And I do have an updated address where he can live with his mother, who is here in court as well.
So we've got Mom, we've got Ms. Anderson, both in court on behalf of Mr. Swan. Okay. Mr. Swan, were you, I may have missed this, but were you working before you got arrested in Clayton County? Doing what?
I got a small handyman service business and I also work for Amazon.
What were you doing for Amazon? Driving?
At the sorting center.
Okay, warehouse, and then handyman is in, someone will call saying, hey, my sink's stopped up, or could you fix this, or? Okay. And is that just you, or did you have? Okay. And when that's not busy, then you do some Amazon work.
Yeah, I mean, I do Amazon, you know, that's just like basically a full time, that's like a backup thing for me, I do.
Okay.
And I also have a nonprofit organization too.
Do you have kids?
Yes, 4.
4 kids. How young is the youngest?
9.
How old is the oldest?
I'll bring my boy to 14.
Pardon me?
14.
Okay. Ms. Tucson has whatever you called the.
Yes, I was just waiting for him to speak. So I went and looked in those, just that one warrant is the only one that he has. And then I also double checked and called Officer Malud. She's the one who's been talking with the family and everything like that. And this is the first time, you know, I just wanted to make sure before I told you guys, that's why I gave her a call. So
Okay.
This is the first time since, you know, it's a old case that he's had issues when this happened in 2020, I believe.
Okay, got it. All right, Mr. Swan, I am going to revoke 4 months, but you'll get credit for all the time you did. We're going to keep you here in the county. I'm not going to sign the revocation order till I get a copy of the bond from Clayton County. I hear what you said, but I want to see it. And if there are no conditions that prevent you from spending time with Ms. Anderson, I will not add those conditions to your probation. Those are fine-tuned things that would be in a bond rather than probation. But I'm going to actually continue you on this probation and ask that it be supervised for 1 year. After which, if everything's going well, you should petition to have it closed out. But just because of Polk not being resolved, I appreciate that's 3 years old, but then this situation, not that very long ago in Clayton County, I think it wouldn't hurt just to make sure everything's going all right in your life and that Ms. Anderson is in a good space. So that's how I'm going to handle this. And I intend for this to address the more recent petition. So it addresses whatever happens in Polk and whatever happens in Clayton. Meaning, if I'm coming up with an example, you go down to Clayton County and plead to a misdemeanor, that plea isn't a new violation of your probation. Your probation is being, I'm revoking you now because of the underlying conduct in Polk and Clayton, whatever that was. So if Polk results in something and Clayton results in something, you're not exposing yourself to another revocation. And if everything goes well for the next year-ish, then you should ask to have the probation closed out in this case. You've been on it for a long time, and for many years, everything was fine. But these 2 things popped up and that brought you back here. I wonder who the judge was who sentenced you. I wasn't a judge back then, so who knows? So again, though, I'm not going to sign that till I get a copy of the bond. Anything else, Mr. Jordan?
No, Your Honor.
And in terms of a residence, what county would you be living in when you get out? Fulton? Okay. Was that your address of record? When the address of record I have, but this was way back in 2020, was Thompson Road in Fairburn.
That's the thing, I didn't change the address in 2012 with probation officer, but they never changed it in the system. That's since Mr. Nash was supervisor.
Okay, well, that's one of the things you're gonna want to get fixed because.
I tried to change it, they never really changed it in their system.
All right, well, you need to keep bugging them because that's an easy way to get a real minor violation is that they send you something and you don't respond to it because it's going to some apartment that may have been torn down and you're not living there. But you're going to give your current address to Ms. Tucson in just a moment, and I bet she'll put it in the system. Okay. All right. Ms. Tucson, are you in a position to update Mr. Swan's address?
Yes, no problem. I am ready.
Let's do it.
2670
2670, okay?
Virginia, like the state. Cove, COVE. Riverdale, 30296.
And is that your mother's address?
Yes.
And ma'am, Mr. Swan can stay with you when he gets out? Just for a little bit or for a while? Okay, well, that could be a while. I don't know. Let's hope not.
Clayton or is this Fulton? It is Fulton?
Yes.
Okay, and then may I have a good phone number for record? I actually don't see a phone number.
Hold on 1 second.
It's like on the borderline, it's like Clayton, it says Clayton, Riverdale, but Fulton County service the area, if that makes sense.
When you vote, you vote in Fulton? Okay, it's Fulton.
Okay.
Yep. It sounds like if you call 911, it's Fulton resources that come and not Clayton resources.
Right.
Yeah, okay, so it's Fulton County. You got a good phone number that we can give to Ms. Tucson?
Yes, I'll give you two of them. I don't know if mine still be active by the time I've been here, but mine would
Your
be.
mom's phone number is good. We could put her phone number on file.
Can you turn the microphone on?
I just sent it to Ms. Tucson, but I'm happy to put it on record. if-
No.
Okay, that's fine, Miss Wood. I could grab it from there if you'd like.
Good. We'll just get it through the chat and handle it that way. Anything else, Ms. Wood, on behalf of Mr. Swan?
No, Your Honor.
Mr. Swan, hope you get back to your handyman business soon and Amazon after you work this out and whatever's going on with you and Ms. Anderson, try to smooth it out.
So what am I leaving here with, knowing that today, what's happening?
So I told you 4 months, I'm revoking 4 months, but you get credit for all the time from January 26th forward. So you've done half of it. And if you get 2 for 1, you've done all of it. But the sheriff figures that out. And when you're released, you're going to be living with your mom. That's what you just told Ms. Tucson. You'll be on probation that will be supervised again. So someone will be a little more active in your life for 1 year. And I said, if that year goes well, you should petition to have your probation suspended, just shut down, because you've been on probation forever. But as I mentioned, I'm repeating myself now, there were these 2 hiccups. Polk was a little while ago, but this situation in Clayton is fresh and the allegations are serious. I don't know what was behind it, and I'm not being asked to work through it because everyone is stipulating that there was this arrest. But those charges are still out there. You may need to go deal with them in Clayton. And then the last thing, again, repeating myself, this revocation is meant to address both those forever. So if you end up pleading to something in Clayton, you're not going to have to come back here and, oh, now you pled guilty to it. This is the sanction, the penalty for those 2 situations, Polk and Clayton. Okay.
And how would I know if the sheriff do the 2 for 1?
Talk to the sheriff. So Ms. Tucson, you can get that revocation order to Ms. Nelson. I'm just going to hold off on signing it till I get the bond from Ms. Wood. So we won't have forgotten it. I just won't sign it till I see the bond. Good luck, you two. All right. We've got 2 more bond hearings and a plea.
I'm ready on all of it, Judge.
All right, why don't we do Mr. Sims, please?
You mind if I still stand up there, Your Honor?
Wherever you'd like to be is fine. It sounds like Ms. Rivers can hear you, so we're good.
Okay. Make half of that.
I think so. Okay, we are here on our first position on the bond calendar. It's State versus Sims, 22 SC 184731. Mr. Sims is here in court. How you doing?
I'm doing fine, and yourself?
I'm okay. He is represented by Ms. Wood, who is seated beside him. And we are working through a motion to reduce bond in Mr. Sims's case. I'm looking for his bond order. It looks like to me in July of 2022, Judge Drake set a 22,500 straight bond. Mr. Sims at that point had been in jail for a long time without indictment. One of those things has changed. He's been indicted, but he remains in jail. So, Ms. Wood, tell me why you think Mr. Sims ought to have a lower bond, and it may have been lowered since then. That's the one I'm seeing in the system. It is to only 2 counts anyway. The indictment is a little different. It has added some counts.
Judge, to just be upfront, this one has gotten even more complicated. I believe, if it's my understanding, and Mr. Jordan can correct me, I believe the case that's on the calendar is actually going to be null crossed. There is an indictment, 23 SC 186528. That is pretty new. That I believe is gonna encompass either some or all of the charges that are on the current case.
And there's a bond in that case that was granted on the 9th, probably by Judge Manning. September 21. Okay, yeah, it's the same case. So I don't know that complicates a lot of things. I'm happy to treat your motion as a motion for bond in the 23 SC. It is, I'm still in that one. Ms. Ford is the alleged victim. She is the mother of at least one of Mr. Sims's kids. That's the intimate partner connection or the family violence connection. But otherwise, it looks like it is I mean, it may have a little more detail, but it's effectively the same case. And so I think we ought to be able to handle it. And I would ask the state if they're going to null pros the 22 SC so that we don't have, because we don't yet have a system where a superseding indictment stays with the same case number. We ought not to have two of the same cases because right now they're two different bonds, they're different amounts, et cetera. So let's start with, is the state null prosing 22 SC 184731?
That is correct, Your Honor. The notes that 88 Willingham left did indicate that that case will be dismissed because as the aforementioned 23 SC 186528 has been the new indictment number.
Okay. Now that we're in that new universe, we have a bond that was reduced by $2,000. It's now 21,000. It doesn't quite apply to this case. It's not quite all the same counts, but that was a dollar amount that Judge Manning felt was appropriate in this case. Mr. Sims. So it says in this bond, he'd been in jail for a very large number of days without indictment, but that's mistaken. I think Judge Manning didn't know there was the 22 SC indictment. So there may have been two CP numbers rattling around for Mr. Sims in connection with alleged conduct against Ms. Ford. But it's not accurate to say that he'd been in jail for that long without indictment. That's not why I should lower or not lower bond. That's where we are right now. So it is a little convoluted. Having worked through some of that, what should the bond be for Mr. Sims in your opinion, Ms. Wood? And tell me a little bit about him.
Judge, he's 24 years old. He has been in custody for 185 days at this time. He is a lifelong Georgia resident. He has 5 children. They're all local. The youngest is 3, the oldest is 7. He has a 10th grade education. He also attended Job Corps. He was working at Wendy's and Steak and Shake prior to his arrest. The reason that we are asking for the court to consider a bond reduction today is because he has a Douglas County hold. I believe it is for a first offender case. And he's eager to go take care of that. He does maintain his innocence on these charges, but is aware of the alleged violation of these arrests, what that will mean for his Douglas County case. So we're just asking for a reduction. We would ask for $10,000 and allow him to go to Douglas County judge.
So Douglas County wants to see Mr. Sims because of a warrant predicated on these facts.
Yes.
It may be more than one arrest because it may be more than one CP number, but it's basically what we'll call our case. That would be what would be discussed in Douglas.
Yes, sir.
And what are you on probation for out of Douglas County, Mr. Sims?
I don't really quite know because they dropped charges. They dropped a case on me and then they had me to plea out to another case.
What's your understanding, Ms.
I
Wood?
think it's similar charges, Judge.
Okay. Would Ms. Ford be the victim in the Douglas County case?
That I do not know.
No.
Different mother of kids?
Yes.
How many mothers of 5 kids?
2.
2. How many of the kids are Ms. Ford's?
3.
And then 2 are the Douglas County mom?
Yes.
I'm going to talk with Ms. Nelson because I think we've done this before, but Ms. Wood, it sounds like your initial objective is to get Mr. Sims to Douglas County so he can work through what's going to happen there. In part, it might create a resolution here. But what I might contemplate, and I haven't heard from the state, I will, is structuring it so that effectively Mr. Sims is loaned out to Douglas. And they might say, insufficient proof, we aren't going to go forward with our revocation. I'd want Mr. Sims to come back and then think more about bond. The fact that he was under sentence for similar offenses in Douglas County when this happened, and I'm assuming that's the right chronology because he's been in jail for so long. There can't have been activity in Douglas County over the last year and a half because he's been in jail. I'm concerned about lowering the bond, but Douglas County will decide what it wants to do. Do either of you have any sense? Oh, you know who should know? Ms. Tucson. Ms. Tucson, do you have Mr. Sims as being on probation out of Douglas County? And if so, how much time is left?
He is actually on probation still. I was actually looking that up and messaging someone from over there about this case because I see that they are aware that he is in custody with us.
Okay, but how does your system say how much time is left?
Yes, he has. It's a lot of time left. It's until 20. Let me see. 10,
You can just tell me the year. What year does it close out?
2028.
Okay.
5 years, 6 months, 22 days.
Got it. Okay. Mr. Jordan, tell me what you want to about Mr. Sims. You've heard what my plan is, which is to figure out, like I said, I think we've done it before, where we get Mr. Sims to Douglas County so he can work on his business there, but it's not by way of lowering a bond.
Yes, Your Honor, the state would oppose a reduction in bond, and I apologize, I'm not sure if ADA Willingham communicated this, but I'm seeing notes in the file that Mr. Sims has actually been in violation of his bond and has been contacting the victim. I'm not sure if Ms. Wood has gotten the jail calls yet, but I do have jail calls that I can send to Ms. Wood as soon as this hearing is over, but I have notes as recent as March 9th that the defendant has been threatening the victim from jail.
Well, that would be another thing we'd want to work through. Why don't we do this? Because I don't want to assume that that's what happened. Don't worry, Mr. Sims. Why don't I will consult with Ms. Nelson about how we could get Mr. Sims to Douglas County. And I would ask that you get Ms. Willingham or your phone person. What's her name? She does the dog cases too.
Ms. Hollander?
Ms. Hollander, yes. That we get those calls to Ms. Wood because she might say, never mind on the bond situation. And that might move the case along as well. So let's try to get those calls to Ms. Wood. This is already, well, I guess the new indictment, you've already done a waiver of arraignment. That's pretty impressive.
I did that, Judge, and then I also saw that it was assigned to Judge Barwick, but I'm assuming we can keep that.
Well, it depends if we null pros fast enough. That's not what's going to happen. I heard you move to null pros it.
Yes, Your Honor.
Okay. All right. I'll let the chips fall where they do. If they come back, if it comes back here, it does. But we'll see how they sort that out. But I need to make a bunch of notes about this one then.
And I just wanted to, as an officer of the court, Your Honor, say that I myself have not listened to the jail calls yet, so I just wanted to make sure that that's clear for the record. It could be a situation where the jail call was misplaced, but that is the notation that I do.
Okay, I appreciate you sharing that, and Mr. Sims needs to understand, I'm not making my mind up about anything. It may be the wrong person. It may be that it's Ms. Ford who's calling. I don't think you can call someone at the jail, but it's Ms. Ford who, so I'm not reaching any conclusions. I would want to hear those before I decide what to do. That might be a reason to make the bond number go up or turn it into it's no bond. But I'm not going to work through that today. I think step one is to figure out if we can get Mr. Sims to Douglas County. And then step two is to figure out, is Mr. Sims going forward a Judge Barwick matter or a Judge McBurney matter? All right. Mr. Sims, do you have any questions? We bounced you around mentally a bit because wait, there's a new indictment, old indictment, different judge. phone calls, this and that. My goal is to see if we can get you to Douglas County.
All right.
All right, Ms. Wood, anything else?
No, Your Honor, thank you.
Sure. Let's do the plea next because we've got Ms. Jackson on from pretrial, and I need her for that, for the plea, but then she can go. And I now know she's got a 4:30 curfew. So Mr. Crump would be next, please.
I'll try to upload those to evidence.com. Ms. Wood, send them to you.
Thank you.
Want the podium, please?
Sure, that's fine. It's 1 to 5 instead of 1 to 10, right? The minimum and maximum is 1 to 5.
What's that?
I'm just gonna ask you if you remember. Trial and you lost, that's what you could be facing. So it's 1 to 5, okay? You're ready, Judge.
Okay, this is position 3 on our plea and arraignment calendar, 23 SC 186024, State versus DeQuarius Crump. Mr. Crump is here in court. Hello, sir.
How you doing?
I'm okay. How are you doing?
I'm doing good.
Good. Mr. Crump is represented by Ms. Wood, standing by his side, and we have Mr. Jordan for the state. Mr. Crump, I was going to ask you, do you waive arraignment and talk to you about how this case will move its way forward? But Ms. Wood tells me that she thinks she's been able to negotiate a plea on your behalf by working with Mr. Jordan, the prosecutor. So what we're going to do instead is put you under oath in just a moment. Mr. Jordan will do that. Once you're under oath, you need to answer his questions and mine truthfully and completely. You also should let me or Ms. Wood know if you've got any questions. I need to be comfortable you're understanding everything we're talking about. None of it is meant to be complicated, but sometimes it gets that way. So if you're confused by something or it's just not going the way you thought it would you let me or Ms. Wood know that?
Yes, sir.
Great. Mr. Jordan.
Thank you. Mr. Crump, can you please raise your right hand? You swear or affirm the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name?
DeQuarius Crump.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone in school?
I'm 25 years old and I finished the 12th grade and I went to community college, but I left and went to play semi-pro basketball.
Understood. Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged with 1 count of terroristic threats?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Have you had enough time to speak with your lawyer, Ms. Lacey Wood, about all the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with her services?
Yes, I am.
Ms. Wood, do you waive formal reading of the indictment?
So waived.
Do you also waive any and all defects in the indictment, including any with respect to Mr. Crump's name?
So waived.
Mr. Crump, do you recall having been arrested on these charges?
Yes, sir, I do.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Ms. Wood, do you know of any outstanding warrants related to this charge?
We do not.
Mr. Crump, has your attorney advised to you the minimum and maximum sentence for the charge that you're pleading to?
Yes, sir.
And just for the record, Your Honor, I believe for terroristic threats, it's a minimum of 1 year and a maximum of 5 years.
Okay.
Mr. Crump, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, the recommendation per ADA Willingham is 2 years to serve 90 days, the balance being probated. The special conditions of probation that Mr. Crump attend a family violence intervention program, that he have no violent or harassing contact with the victim, that he complete 20 hours of community service, and that he had not have any drugs or alcohol while on probation and be subject to random testing. And also that he have no weapons while on probation. Was that the recommendation that was communicated to you, Mr. Crump?
Yes, sir, it was.
Do you understand that the court does not have to accept that recommendation?
Yes, sir.
Do you understand that the court can sentence you to the maximum on this charge?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes, sir.
Are you currently on probation or parole?
No, sir.
Do you understand that since you are being placed on probation, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Are you a United States citizen?
Yes, I am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir.
Do you understand that your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, and the ability to obtain employment?
Yes, sir.
You understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a commission of a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison.
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights, which I will now list off: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to have the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the sole charge of terroristic threats in indictment number 23 SC 186024?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charge against you?
Yes, it is.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that since this is a felony charge, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
And Ms. Wood, do you advise to Mr. Crump his deadline for filing a direct appeal?
I did.
Thank you, Your Honor. For a factual basis, on November 27th of 2022, at the location of 245 Amal Drive, AMAL, Mr. Crump and the victim, Ms. O'Hara, and I have two different spellings here, Your Honor. I would defer to the spelling that's on the indictment.
Yeah, I found it in the indictment.
Okay.
But I'd spell her first name for the court reporter as well. They're
Absolutely.
both
I
different.
will refer to her as Miss O'Hara because I don't want to mispronounce her first name. It's COSHARALYN. At the time of the incident, Mr. Crump and Miss O'Hara lived together at the previously mentioned address. Ms. O'Harrell was pregnant with Mr. Crump's baby. A neighbor who wished to remain anonymous called 911 to report that he heard that Mr. Crump was screaming that he would kill O'Harrell. When officers arrived, O'Harrell stated that she and Crump got into a verbal argument because Mr. Crump was intoxicated. During the argument, Mr. Crump started throwing objects around the house and threatening to kill O'Harrell. O'Harrell played a recording of Mr. Crump that stated, "I will kill you, you and that baby." Mr. Crump did admit that it was his voice on the recording. He said he only said those things because he was angry that Ms. O'Harrell was accusing him of cheating. Glass could also be heard breaking in the recording. That does conclude a factual basis, Your Honor. According to Ms. Willingham's notes, she did indicate that Ms. O'Harrell does want to co-parent with Mr. Crump, given the no violent or harassing contact provision. So we would ask that Your Honor accept this negotiated plea.
All right. Ms. Jackson, tell me what you've got for criminal history for Mr. Crump, please.
Your Honor, the defendant has 5 cycles out of Mississippi. The defendant's last arrest was November the 22nd, 2021 out of Richland, Mississippi, where a failure to appear, the underlying charge was aggravated domestic violence. There was no disposition for that arrest. The defendant does have a history of failure to appears. There was one in 2021, one in 2020, and one in 2018. Nothing in addition, Your Honor.
So thank you for that. You're not able to tell if Mr. Crump has any felony convictions, or there was a failure to appear for a charge that sounded like it was a felony charge.
Yes, there were no convictions listed in the GCIC, Your Honor.
Got it. All right. Thank you so much. And thank you for being here today.
Thank you. Have a great one.
You too. Ms. Wood, what do you want to add?
Judge, I just want to let the court know, Ms. Willingham and I both were trying very diligently to get dispositions on some of that stuff out of Mississippi. I spoke with the clerk's office in Ridgeland this morning. There was a dismissal. However, they couldn't send me or fax me a copy of that without a check or money order being presented. So just wanted to let the court know that information. Miss O'Harrell has been emailing and calling me. She's very sorry she couldn't be here today. She's a school teacher and her break did not line up with our court calendar. From the start, Mr. Crump has been wanting to resolve this since I came on board, which was like a week ago. He's 25 years old. He is originally from Jackson, Mississippi. They moved here together last summer.
They meaning Ms. O'Harrell and Mr. Crump.
Yes, Judge.
Okay.
They are expecting a child. One of the reasons it is so important for him to take responsibility and plead today is because she has a high risk pregnancy and she's having complications and she really just needs him out to help her get ready for the baby. He does have a 12th grade education. As he said, he played semi-professional basketball. Prior to this arrest, he was working for a staffing agency, so we don't anticipate any issues with him finding gainful employment. This will be his first felony conviction. I did go over the pros and cons of the First Offender Act with him. He feels that his 117 days in Rice Street has really been the wake-up call that he needs, Judge. And so he wants to ask the court to sentence him under the First Offender Act. And so we would just ask that you accept the state's recommendation.
And you're requesting a first offender disposition.
Correct, Judge.
Any objection to that?
State has no objection, Your Honor.
Okay. And we just don't know if he's eligible because Mississippi wants money to share whatever the records are.
$5 check or money order, Judge.
Okay. But Ms. Jackson did pour over the records and she didn't see a conviction in there. She's pretty thorough with that. Okay. Mr. Crump, anything you want to add?
No, sir. Not that. I just want to say that I really got an experience at Rice Street and I do not want to be there any longer.
I understand that. I hear that from people from time to time.
Yeah.
Is that the longest you've been in jail?
Yes, it is.
In Mississippi, were you ever locked up? I know you had a few arrests, so I guess you were locked up a little bit, never that long?
No, never, not even a day or two.
Okay, so this is definitely an eye opener.
Yes, it is.
All right, so far everything's intact. You haven't been too bad?
Not too bad, but yeah, but
Okay.
not too bad at all.
Tell me what kind of work you do through the staffing agency.
They have me doing different kind of assignments. I can go work at a warehouse. I've been working at a car auction. I worked at a number of different things, but I also make money from my basketball as well. I still play semi-pro basketball.
Yeah, tell me what that means. Does that mean like you get paid every other game?
Every game I play.
But why is it semi-pro? If you get paid, you're pro.
Yeah, it's just not NBA.
It's not NBA. Okay, but still, I mean, my guess is if you and I went one-on-one, you probably win. So you get paid. It's just not was it called like the G League or the?
It's not the NBA G League. It's just the next step to going overseas.
Got it. Okay. Is that a goal someday to maybe get overseas to play?
Possibly.
How tall are you?
I'm 6'3", 6'4".
But like if I really met, is that like what you publish 6'4"? You don't look 6'4" to me.
I'm 6'4".
Okay. All right. Whatever you say. Would Ms. O'Harrell be able to go overseas with you?
Yes, she would.
Okay. All right. First offender is a great opportunity, especially if you aspire to go places, but it carries risks with it. If I follow this recommendation, you're going to be on probation for not so long, but still over a year. And if you were to mess up again, and it sounds like you've had similar kind of dust ups, I don't know if it's with Ms. O'Harrell, but at least one of those arrests in Mississippi sounds like it was you got angry and put your hands on someone you cared about in a way you shouldn't have. And something like that happening while you're on probation will get your probation revoked. As a first offender, not only could I revoke if you are a first offender, not only could I revoke your probation, but I could resentence you as a felon up to the maximum. Now, it's only 5 years here. There are other people where they're getting a 2-year deal out of what could be a 20-year deal. I'm letting you know that if we are together again, because there are allegations that you threatened Ms. O'Harrell or put your hands on her in a way that she didn't want, that I will take away your first offender. So you'll become a felon and I get to resentence you. Like, it's interesting. I gave you probation. Now I'm going to give you 4 years or something. I don't know what it would be, but it would be serious. And I share that with you, not because I think, you know what, you're going to be back here. I need you to appreciate the consequences if you're back here, because you need to make an informed decision about whether you want to be first offender. It's a good thing because your record is clean. While you're on probation, you're not a felon. You don't have to tell anyone that you're a felon because you're not. And if you successfully complete probation, case closed, expunged, no criminal history on that front, no convictions. That's good. You're not going to be able to do semi-pro forever. Eventually get kind of old and tired like me, and then you're going to need to do something else. And it's harder to find those something else's if you've got a felony conviction. So it can be good, but it's got a risk. Do you feel like you understand the good and the risky of first offender?
Yes, sir, I do.
Do you want to be sentenced as a first offender?
Yes, sir, I do.
All right. I find there's a factual basis for your plea. Sounds like the state's case was pretty strong. You were on tape. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this, and knowing means you've understood it all. Do you agree with both those things?
Yes, sir.
I'm sentencing you under the Probation Options Management Act, which means that while you're on probation, if you've got a small violation, you miss a meeting or something, you in probation will resolve that. But if it's more serious, any kind of arrest, thing like that, that comes back to me. Do you, Mr. Crump, authorize my staff to sign the indictment indicating that you're entering a guilty plea in the case?
Yes, sir.
Ms. Wood?
Yes, Judge.
And Mr. Jordan?
Yes, Your Honor.
All right. I will sentence you as a first offender. I will sentence you to 2 years to serve 90 days. You'll get credit for all the time you've been in. The balance will be probated. Special condition of probation number 1, no violent contact with Ms. O'Harrell. So you can be around her. You better be around her. She's about to have a kid with you, but it cannot get violent. You'll need to do 20 hours of community service. You'll need to complete a family violence intervention program. That's not just one class for a half hour, but it's a series of classes over a series of weeks, and you'll need to complete that. And you're going to need to submit to a drug and alcohol abuse evaluation. So you'll meet with a professional we'll get a sense of, you know what, you drink a little bit too much or you use something else. And if that expert recommends any treatment, go to AA meetings or something like that, that treatment will become a part of your probation. So 4 special conditions: no violent contact, complete family violence intervention program, 20 hours community service, get this evaluation. And if that leads to treatment, follow that treatment. Mr. Jordan, anything else?
Nothing further from the state judge.
Ms. Wood?
Yes, Judge, I don't think, or I missed it if you did. While he is paying for that family violence intervention class, is it okay if his probation fees are waived during that time?
Sure. What I'll do is I'll waive probation supervision fees for the first 6 months. If you haven't finished your family violence intervention program by then, pick it up. But you'll be paying the supervision fees after those first 6 months.
Thank you, Judge.
All right. Last thing is for you and Ms. Tucson, who is on virtually, to talk about where you live so she can give you reporting instructions.
Yes, sir.
And maybe it's that Amal Drive address, but let's find out. Ms. Tucson?
Hi, thank you. Miss Wood so kindly provided me with that address via email on Amal Drive. So I will just need a good contact number for you, Mr. Crump.
601-760-7299. That is my cell, and I'll also give you Miss O'Hara's cell.
Okay.
601-918-6305.
And what is Miss O'Hara's first name?
Kasharlin.
Kashara.
Yes.
Okay. And I'm gonna have you reporting on April the 10th.
Okay.
Let me double check that date. Yes, because that Friday is a holiday. April the 10th, okay? At
Yes,
8
ma'am.
a.m. I'm gonna also call you to confirm this and send you or Miss Wood the reporting instructions. Okay, for you to report will result in a warrant. Okay. Probation is at 276 Memorial Drive. I don't see that you've had to go there before. It's right around the corner from the courthouse.
Okay.
Okay. This is yours to keep. I'll send Ms. O'Hara everything via email too, okay?
Okay.
All right, you're good to go.
All right. Good luck, Mr. Crump.
Thank you.
Be good to Ms. O'Hara. She's got your baby in there.
Yes, sir. Thank you.
Okay.
Thank you, Judge.
So I've got about 10 more minutes before I got to roll off the bench, but I think we only have one more thing, which would be Mr. Wyatt's bond hearing.
Be so quick, Judge.
Very quickly.
Excellent.
I didn't hear it, Judge.
Pardon me? Wyatt.
Wait.
Yep.
No last minute mention of jail calls either.
I may know Mr. Wyatt. We had a guy in drug court named Scotty Wyatt. I don't know if it's the same one, but we'll see. He and I will recognize each other. It is, it is. Hey, Mr. Wyatt. I'm all right. Good to see you.
All right. Been a while.
It has been a while. Let me send this one email about Mr. Torre and then we'll get going.
So we're just gonna ask the judge to set up on those people.
Hmm?
You've got 2 access instead of 1.
Oh.
All right. Let's get on the record with position 2, State versus Scotty Wyatt, 22 SC 184938. And we are here in this case to talk about bond for Mr. Wyatt. I'm pulling up his case right now so I can follow along. So there is a bond in place. It's a question of lowering that bond. All right, Ms. Wood.
Well, Judge, Ms. Primovic kindly pointed out, so he does have a $20,000 bond. However, when the state indicted the case, they added charges. So that's, there's an additional ag assault and a battery. So we would need an amount on those as well if the judges, or if the court is inclined to do any sort of reduction. He has an address he can return, or he can go to. It's his sister's place in Madison, Georgia, 577 Madison Avenue in Madison, 30650. He is 52 years old. He's a lifelong Georgia resident. He has a 10th grade education. He does have his GED. He has been working at Mary Mac's as a dishwasher. Yeah, we're just asking for a reasonable reduction. He has been in custody for 368 days. So since March 21st of last year. And Judge, I do want to note, this is Ms. Feely's client. I'm just standing in today.
Okay. So it's interesting, the two aggravated assaults, it's the same day, same alleged victim. I guess it's just two different objects. There's allegedly a threat with a knife and then a threat with a stick. Oh no, actually hitting with a stick. And then the family violence battery is the laceration that was caused to Mr. Ponce, maybe with the stick, maybe with the knife, who knows? But one alleged victim, all on March 21st of last year, hence the 368 days. Look at that. Okay. Mr. Jordan.
Yes, Your Honor. The state would oppose a reduction in bond. We would contend that the bond that was set is appropriate, given Mr. Wyatt's criminal history. I do have a note here that he has at least 7 convictions. Some of the convictions are rather old. There's a 1989 burglary conviction, a 1993 aggravated battery, a 2003 battery. I have a note that there was originally an aggravated assault in 2008 that was pled down to a disorderly conduct, and also a criminal trespass in 2013. Your Honor, given Mr. Wyatt's criminal history, we would assert that the bond is appropriate. We would oppose a reduction in bond. Your Honor, it does not look like the state has been successful as of today in contacting Mr. Ponce.
Right now, depending on how one looks at it, Mr. Wyatt has no bond for a couple counts. But a judge did set a bond for all the counts he was facing at some point. I guess it was when this was the CP case. Are you arguing that Mr. Wyatt should remain in no bond status, or that I ought to enter a new bond for that dollar amount, which I think is $20,000, but just allocate that across the three counts, so that if Mr. Wyatt can make that bond, hey, a judge has already said that's okay. You just don't think it should be lowered.
Yes, Your Honor. The state would much rather you allocate the bond and spread that bond amongst the charges that were added by the state. The state doesn't believe it would be appropriate to hold him in no bond status just because we added charges.
Okay. Ms. Tucson, is Mr. Wyatt on probation?
No, Judge, that probation ended.
Okay. All right. Anything else, Ms. Wood?
No, Your Honor.
All right, Mr. Wyatt, we go further back than you and Ms. Wood or you and Mr. Jordan. I remember our time together in drug court, a little bit of time. So I will revise your bond so that that dollar amount applies to all the counts. In looking at what you were arrested for and what you were ultimately indicted for, it's all one situation. And the state has just refined the way that they're charging it, broken it into smaller pieces. So I'm not going to overrule what a different judge did. I'll just apply that number to these counts so that if you are able to make that bond, then you'll be all set. If you're not able to make that bond, then Ms. Wood knows how to get you back in front of me. I'm looking at the schedule here. We're going to be back together in 1 month and 2 days. For the final plea in this case. By that time, the state needs to have done everything it needs to do to get ready to go, and we'll have made a final offer to Ms. Wood, who will be Ms. Feely, so her colleague, who will talk to you, and maybe you all work it out. If not, then we'll get you into court for a trial. We even have a trial calendar set up. And I share that with you, not to say, great, you can just sit in jail till then, but to let you know that if this dollar amount is not something that you can make, you shouldn't despair, because we're getting you back here in a month and then soon after that for the trial. So it may be something that works out with a plea, and if not, we'll certainly get you a trial. Okay?
Okay, one question. How does it end up with 2 aggravated assault?
It's a great question. And Ms. Feely, so Ms. Wood's colleague, can talk to you about that. All I can tell you in reading the indictment is that there's an allegation that you brandished a knife with Mr. Ponce. You didn't touch him with the knife, but you had a knife. And then in that same, whatever was going on with you and Mr. Ponce, you hit him with a stick. So I don't want you to react like, I did nothing like that, but that's how it's 2 different pieces, because it's 2 different weapons. That's the allegation. I wasn't there. Don't know what happened. It could be that Mr. Ponce had a bazooka and all you had was a stick and a knife. And that's a very different story. But that's the best I can answer your question right now. Ms. Feely will see you soon to talk to you more about this. And you guys will figure out, because you're going to need to get ready for this April date. So just right next month. So we can figure out what's happening. All right.
Okay, same courtroom?
Same courtroom, same judge, just different lawyer.
Okay.
All right. See you soon.
Bye, Mr. Wyatt.
We'll bring on Mr. Hill next.
And Your Honor, I know Ms. Walker's no longer going to be with us because of the new program, but Mr. Hill would be one that could be worked out very easily.
Okay, it's good to know. I will let her know that, because she's going to need to get someone on this. Mr. Hill can just be right there at the door. Thanks. Hey, Mr. Hill, how you doing? I'm all right. I'm Judge McBurney. You've got an old case, but we couldn't find you for a while, and we did find you. I just need to let you know we are working on lining up a lawyer for you. For some reason, I don't know why, the public defender can't represent you. It's going to be what we call a conflict defender. So I need to get a conflict defender assigned to you to come out and meet with you so we can move your case forward, okay? I thought that person would be here today, couldn't make it. So I'm going to work on that, make sure that person comes to see you. We'll bring you back in here in the next couple of weeks and get things moving, okay? All right, thank you. All right, I think that is it. Mr. Jordan, anything else?
No, Your Honor.
Ms. Wood?
No, Your Honor, thank you.
All right, thank you everyone for a productive afternoon. I don't have any criminal tomorrow on my calendar, so I guess